Bună dimineața, good morning! Bine ați venit la cea de-a doua ediție a Conferinței de Drept European al Afacerilor, o conferință pe care în mare parte o să o avem în limba engleză, dar vom avea anumite prezentări și în limba română. Le mulțumim tuturor celor care sunt prezenți aici în sală. Este o conferință în format hibrid, așa cum v-am obișnuit. Conferințele Facultății de Drept, cele internaționale în special, sunt în format hibrid. De anul acesta vom avea și două conferințe naționale organizate împreună cu facultăți partenere ale altor universități. Una va fi organizată aici la noi la ASE, o alta la Sibiu și acelea vor merge în format hibrid. Avem invitați de seamă, atât online cât și aici de față, și le mulțumim pe această cale că au acceptat invitația noastră. Încercăm prin această conferință să aducem atât speakeri internaționali, cât și personalități ale dreptului național, dar preocupați de dreptul european. Și, într-adevăr, la Facultatea de Drept avem o anumită secțiune, o anumită parte care este dedicată dreptului european. A fost în ultimii 20 de ani și chiar mai mult. Și aceasta ne oferă șansa de a interacționa cu partenerii noștri din străinătate, cadre didactice, dar și practicieni. Facultatea de Drept a demarat acest proiect în cadrul unei structuri mai complexe, respectiv una care ține atât de partea didactică cât și de cercetare. Așa cum am zis mai devreme, avem în predare unele discipline de drept al Uniunii Europene, fie că vorbim de dreptul instituțional, fie de cel material. Avem anumite discipline punctuale în anumite domenii și noi încercăm să dezvoltăm atât dezbaterea cât și componenta didactică. Avem în pregătire deja acreditat un master de drept european al afacerilor. Sperăm ca în 2 ani de zile să avem și proprii studenți la acest master și acesta, de ce nu, să fie ulterior transformat sau duplicat și într-o limbă străină. Ne gândim la o dublă diplomă pe studii de drept european al afacerilor. De asemenea, în cadrul licenței avem o disciplină de drept european al afacerilor care, de fapt, pregătește studenții care doresc să specializeze în acest domeniu, și alte discipline care sunt fie legate de piața unică, fie de alte componente de dreptul Uniunii Europene. Și consider că pe lângă partea didactică putem veni, și am venit de-a lungul timpului, componenta de cercetare, iar această conferință este unul dintre elementele acestei zone. Noi am avut de-a lungul timpului secțiuni în cadrul conferinței noastre de dreptul afacerilor care au fost dedicate dreptului internațional și în special dreptului european. Și am avut în cadrul departamentului nostru personalități ale dreptului europene care, pe lângă componenta științifică, respectiv manuale, cărți, au oferit lumii noastre academice și cursuri importante, fie aici, fie la alte universități, predate cu o legătură strânsă de această disciplină a dreptului europene, indiferent de generalitatea sau specializarea ei. Și aici menționau aici doar pe doamna profesor Lefte, care mi-a fost apropiată și care anul acesta va primi și o diplomă de onoare în cadrul sărbătorii celor 110 ani ai universității noastre. Așa că continuăm seria de evenimente dedicate dreptului europene, această zonă de cercetare, adăugând evenimente deja organizate în timp, o a doua ediție a acestei conferințe, și dorim prin aceasta, alături de cadre didactice, dar și de studenții noștri, să avem noi proiecte. Deja pe partea de cercetare avem câteva proiecte care au fost dedicate zonei digitale mai mult, dar cu apropiere de piața unică digitală, și ne bucurăm că noștri colegi au ales să cerceteze în special în aceste domenii și sperăm să venim cu noi evenimente ceva mai punctuale și nu doar conferințe internaționale sau naționale, ci și dezbateri și workshop-uri care, într-adevăr, să trateze anumite subteme, să spunem, din această arie destul de largă. Le mulțumesc invitațiilor, o să trec și la partea de engleză, având în vedere că vom începe limba engleză. So welcome to the second edition of the Perspectives of European Business Law. It's a new conference that this faculty launched last year. We are pleased to welcome here in the campus some distinguished guests from abroad. Also, we have some online. We have also practitioners, scholars, students, some of them here, as you can notice, but also online. I want to thank them. For us, it's very important to promote this area of European law, and especially of European business law. In our faculty, in time, because we have been teaching mainly and researching European law at this department, faculty, for more than 20 years, we initiated different projects, and this is an area in which we develop both research and teaching. Just mentioning that we have some subjects that are taught at this faculty in strong connection with European law. We have even a master degree called European Business Law that we hope in 2 years when we'll have our own students, to actually have this master on the market. It is accredited, so we have it legally, just we need the students in order to start with it. Next to the master, we already started now in the second semester of a second year with a subject which is called European Business Law, and its introduction hopefully of the master to come, but also other subjects related to European law, either institutional law, of course, or material law in different areas. So next, the one that I just mentioned, we have one on European contract law and single market. We have also digital law with a component in this area. We have even fundamental rights, if you want, even if you go a little bit broader. So we have different subjects at Faculty of Law, so we are attracted and we hope that in time we can develop even more this area. Just from the area of teaching, I want to mention a person that this year will actually get a medal for her activity, and she's very close because she was the one coordinating me at the beginning, and she's a famous professor in European Union law, Mrs. Cornelia Lefter, and next to her, many others here taught in time at this university and other universities different courses of European law. So this just pointing out our interest and, of course, our involvement in the development of European, especially business law, at this new faculty created at the Bucharest University of Economic Studies. Next to the teaching, in time, we also involved in research. On the side of conferences, this is the second international conference, but in time we had sections in international and European law, of course, at the business law events that we organized. We have a 13th edition of our conference in the autumn, and over there always we had us and our guests talking about matters in European business law. And yes, we developed this, and we want actually to develop more. On the side of research, pure research, we have different projects. We have colleagues who initiated projects in, for instance, the digital single market, or others which are somehow connected to areas of European law. And we actually here at the Dean's office back them up in all these projects, and we hope we'll have in the future even more. And we hope that our professors, our colleagues, other professors in the teams, but also the students who started in the last years engaging in the research of European law, to come with new projects and to have them next to the already existing international or national conferences. As you noticed, we have this conference both online and face-to-face. So we have some guests here, but we have others online. This is something that we started, of course, in the pandemic, but we are pursuing with this. So all our conferences, international and national, are in a hybrid form. So that's why we hope that in time, the idea is that we'll actually develop this. And starting this year, we'll have even national conferences in a hybrid form. We'll have one now at Sibiu with our partners from there, in the autumn with the university from Alba Iulia, but here at ASE. So not saying more, but just an introduction on how we get involved in the European law and especially European business law area. And I want to thank everybody here and online for also getting next to us in this project and being part of this project. As you notice on the schedule, we have at the beginning some keynote speakers that I want to thank. Some of them came to Romania, some of them just visited us anyway from Romania and visited us here, and they allocated their time this day for the conference, and I want to thank them. And they will present some interesting issues. Hopefully we'll have some even debates after each part. What we do with the conferences, we have two parts. We have an opening session, we have the keynote speakers, and then we have an academic forum where we'll start debating on certain matters with the scholars and the practitioners in the field. And I want to thank and also invite first Mrs. Chantal Demol, a colleague, because I can say I'm co-teaching with Chantal a course here at our university. Clearly, we cannot teach for the moment, I suppose, in English at bachelor law. Because law is still national. We say still because it's a conference of European law. Yeah. So maybe in time we'll change this, but the harmonization, or maybe even more, has to go deeper in order to talk about studies in European law in foreign languages at bachelor. At master, maybe yes, we can have by double the diploma. But we are teaching a certain subject, international contract law, and over there have an area of European contract law at a certain section, a certain MBA from our English sections. And next to the co-teaching, Chantal was involved in some other projects that we had in the last years, and I want to thank her by saying that it was our pleasure and also our honor to have her at the desk teaching, but also to have her insights on the projects that we developed in the last years. Chantal is a professor, have been for the last 26 years, if I'm not wrong, at Universitat de Barcelona, teaching civil law, but becoming very preoccupied with the area of European contract law, with common projects on unification of private law, but also with the consumer law, which we know already it's harmonized. So getting like this anyway got also to my area and also to some of my colleagues. So in that moment we found common grounds for the research and teaching. Chantal also is involved in consulting activity as a lawyer, mainly in civil law, also real estate, construction law, and she was involved in management activity, let's say, of some academic institutions. As I know, because I visited Barcelona and I was, anyway, not with her, with somebody else, I just was in a partnership over there and I found out about her being in a certain board. She was actually the director of a certain international master at ISDE. She was also a member of, she is a member of the civil law section of Barcelona Bar, director of the legal dissemination group, secretary of the Center for Research and Development, Real Estate and Commercial Property, also involved in the activity of the Association of Property and Commercial Registers of Spain. So you can notice she's involved in private and public projects, both academic and of practitioners. So thank you, Chantal, for attending our conference. Thank you for being this week with us, both in activity of teaching, but also now in research. Thank you.
Thank you very much. It's a pleasure to be here with you, and I really want to thank Professor Ovidiu to invite me. It has been a great opportunity to stay here all this week to meet business law students, law students, and I must say that I felt in love of Romanian people and of Bucharest and the history of Romania, and it has been a very, very great experience to be here, and I hope that I can come back and strengthen this relationship with your university and with my colleagues. So, Professor Ovidio told me that I could speak about European issues. This week I made some lessons about consumer law, about professional careers, but today I would like to focus in a field which in fact is the one that was at the beginning of our relationship, which is construction law. And because we belong to this European Society for Construction Law, a society which was created just after Second World War. It is a very, I consider a very good project because it was after the war, Europe had to be rebuilt, and so French, German, Austrian, and professors from different universities in Europe decided to create this in order to make research and to think about the best rules for construction law. Now, unfortunately, we are living a war in Europe. Just here, I am very impressed not to see that it is so nearby. And well, hopefully it will stop early. But after, we always need to rebuild, and construction is something good and something which can give economic growth. And Europe is very concerned on this. And they want, on the one hand, they want to promote energy efficiency, green economy, and also to boost the economy after the pandemics, and well, and also, of course, after the war. So I can't see, I don't know if I can, okay. So I prepare something in order that you can follow it, but maybe you cannot see the whole screen, no? Oh, yes, yes, yes. It's in green, and so it's difficult to read. I wanted to be green, but it's not very good for reading. Maybe, yes, I prefer. Yes. Okay, I can stand up. Oh, no? I sit down? Okay. Okay, so I called this speech Energy Efficiency and Renovation in European Building Sector. So here is the summary. I divided my speech to see the importance of the building sector to achieve energy and environmental goals. Then we will see which are the European regulations to boost energy efficiency in buildings. And then we will focus on this renovation wave for Europe, both strategy and action. And finally, I will comment a little bit what has been done in Spain. Okay, so the importance of the building sector to achieve European energy and environmental goals is clear. This sector is crucial. Think that buildings are responsible for approximately 40% of European energy consumption, 40%, almost a half, and 36% of the energy-related greenhouse gas emissions. Buildings are therefore the single largest energy consumer in Europe. Moreover, citizens consume in heating, cooling, and domestic hot water 80% of the energy. The 80% of their consumption is in these fields. At present, about 35% of the European buildings are over 50 years old, and almost 75% of the building stock is energy inefficient. And I want to comment that I enjoyed walking in your street in Bucharest, but I wanted to do this speech because I think that for Romanians, this program can be so useful, because you know that you have some buildings which are very beautiful, but unfortunately they are not refurbished, they are not renovated because of the lack of funds, because it's too expensive. So I do think this is an important program, and for business companies here, it can be very interesting to tender and to try to have to get in this strategy and action. Only about 1% of the building stock is renovated each year, so we have many opportunities to do. Of course, to have better energy efficient buildings also improve the quality of citizens' life, alleviate energy poverty, improves health, improves better indoor comfort levels, and it creates green jobs. Which are the European regulations? So we have mainly these two directives, you probably know them, of 2010 and 2012. One is more specific for performance of buildings, energy performance of buildings, and the other one is in general about energy efficiency. Their goal is to achieve a highly energy efficient and decarbonized building stock by 2050, to create a stable environment for investment decisions, and to enable consumers and businesses to make more informed choices to save energy and money. In fact, these directives, so now it's more than 10 years ago that they were approved, and it is considered that buildings consume only half compared to typical buildings from the 1980s. So there's already an effect. So these two directives of 2010 and 2012 have been amended in 2018 and 2019. I had the occasion to give a lecture at the European Commission in 2017 when all these amendments were being prepared. So these amendments are part of the Clean Energy for All Europeans package, you know, this energy policy framework to help us to move away from fossil fuels towards cleaner energy. And these amendments introduced new elements and show the strong political signal on the Europeans' commitment to modernize the building sector in light of technological improvements. And they want to increase building renovations. So from 1018, there's this idea of renovation. Just to mention, this directive has been transposed in Spain, and it had an effect on my field of law, private law, civil law, because, and I suppose that probably you transposed it, but for instance, just to give an example, from January 2023, all non-residential buildings that have a parking use area with more than 20 spaces, either inside or in an attached outdoor space, must comply with the requirement relating to the minimum endowments for electric vehicle charging infrastructure. So there are practical changes in national legislation. And afterwards I will comment another issue important also for private law. So let's see which is this renovation wave, this strategy and action. It was published in October 2020. The name is A Renovation Wave for Europe, Greening Up Buildings, Creating Jobs, Improving Lives. And it's a complete action plan with concrete regulatory, financing, and enabling measures to boost building renovation. The objectives is to at least double the annual energy renovation rate of buildings by 2030, to foster deep renovation, to create green jobs, as I said, and also to boost economic recovery after the COVID-19 pandemic. We must think that construction sector is largely dominated by local businesses, and building renovations can also play a crucial role in European economic recovery. But of course, we need that these small businesses arrive to the funds. The renovation wave identifies 3 focus areas. First, tackling energy poverty and worst performing buildings. Another is public buildings and social infrastructure. And finally, decarbonizing heating and cooling. These are the 3 areas. And so, the main question, how do we finance it? So, the renovation wave includes also a document which presents available EU funding budget solution that could support the renovation wave in different ways. Through direct investments, leveraging private investments, research and innovation, and to address market barriers and available technical assistance. I wanted to mention this plan that I put the link because I think it's not very well known, but if you can have a look, it's the new European Bauhaus Initiative calls, which call on all of us, citizens, companies, to imagine and build together a sustainable and inclusive future that is beautiful for our eyes, minds, and souls. And it's written like this, no? It seems a poem, no? It seems romantic and utopic, but it's a plan. And they define what is beautiful. Beautiful are the places, practices, and experiences that are enriching, inspired by art and culture, responding to needs beyond functionality, sustainable, in harmony with nature, the environment, and our planet, inclusive, encouraging a dialogue across cultures, disciplines, gender, and ages. So, very good goals, no? But just to see that is something practical, I put a publication of October 2022, and there was an open call for innovative projects in cities. So the European Urban Initiative launched a €5 million call to support urban innovation and cities' capabilities to build a sustainable urban development based on the new European Bauhaus values. So it's a lot of money. This launch is thought more for urban cities, I mean for the town halls. But that's only an example, because there are prizes, there are also funds for businesses. So if you may have a look. Maybe it can be a useful information, and maybe you can fulfill the requirements. And just to end, a little mention to which are the rules which have been approved in Spain to transpose this amendment, this renewal plan. We had a new law in 2021 on climate change and energy transition, and well, that they want to use material with the lowest possible carbon footprints, improvements in the accessibility of buildings. They boost renovation, and they facilitate self-consumption photovoltaic installation in condominiums, and zero emissions heating and cooling systems. Another rule has been this of October 2021. This is more on financial issues, but also it amended our horizontal, our rule about condominiums, in flats, and the decision-making by communities is facilitated in order to change heating systems or energy systems in the buildings. And finally, we have this recent law of 2022 on the quality of architecture. And in Article 2, they said that one of the purposes of the law is to increase the number of near-zero energy consumption buildings, not only in new construction, but also through comprehensive approaches in the renovation of the existing building stock. So I'm sure that you also have rules which in Romania which are implementing all this, and I think it is a very important plan of the European Union, and it can be very useful for Romanian businesses. So thank you very much for your attention.
Thank you, Chantal, on the insights, especially how Spain actually reacted to those. Now, if you have any questions from the room or online. Nothing? Now, just to extend a little bit the debate, I would address one. Now, taking into consideration what happens now and with the new strategies of European Union to get more independent from the energy point of view, if you see in the near future even new harmonization tools in this area, I mean, in connecting what we have with the environment protection and the NZEB buildings and the new push anyway towards the new renewable energy or more renewable energy in order to get to a more independent Europe from the energy point of view. If you actually, this can go even further than now. We are now at the step of, we transposed most of us, but now we have to put in progress, so we have to actually apply. If you actually can see, just happen for instance in company or others, the push, meaning we have some directives, then we came with new ones. So we're in consumer, we had the minimum, and then we went to the maximum harmonization. If you can actually see in the new future, take into consideration the war, take into consideration the new events of new harmonization tools that actually may go to something else than we have now with this.
So your question is if I think it will go further.
Yeah, and how fast? And that now we transposed, we're applying, but if we can, actually, we have to do it even more than we have now.
Well, I know that the European Union, you see, the first directive, 2010 and 2012, then an amendment 6 years later. 2 years later, well, we had the pandemic, 2020, the renewal strategy. So more or less, I think it will go faster and faster. Not periods of 8 years, but almost each 2 years we will have changes because, of course, it is also very related to technological improvement, and technology goes before law, and law is always after. And so I'm sure that we will have new issues, new regulation, and in fact they are already thinking at the European Union to change the amendments of 2018 and 2019. So it's interesting to be informed and to follow all these issues. And the European Union published everything, so it's good to have a look to the website and to go to seminars like that in order to be informed.
Thank you. Now, thank you, Chantal, for the, as I said, insights and for your work, especially here at our faculty, but also in Barcelona. I have to mention that with Chantal, we established a partnership with the Universitat de Barcelona on the Erasmus program. When I was a student here as an economist, a future economist anyway, I applied. Even if I didn't go to Barcelona because I decided to start a project in Romania, we had at that time, so I'm speaking about 2000, and for many years we had no relation with Barcelona from the Erasmus point of view, maybe others. So we re-established this, and we are thankful to Chantal and also the Vice Dean and the Dean over there for opening the door for our very young faculty. Thank you, Chantal. And now we switch from, anyway, connected to the market in a way or another, but we switch from this area of construction to competition, as I understand, and not anything in competition, but actually a judicial part with the title French Judge and the State Age. The next speaker came especially for this conference to Romania, and we want to thank him for that. We have here Jérôme Sanjou de Berge de Salut, Judge Rapporteur, the litigation section at the Council of State, expert in legal affairs at the French Ministry of Foreign Affairs, member of the Council of State of France, and former government agent of France at the Court of Justice of the European Union, if I recall right. Thank you for your presence here. Thank you for preparing, and I'm pretty sure it will be interesting debate after the presentation, and also maybe during the break with our colleagues here in the room. And we hope to see you more and more at our events. Thank you.
Oh, thank you. Thank you, Mr. Dean. It's a great honor for me to make, for the first time, a presentation in the law faculty of this academy. And as has just have been said, I'm due to talk to you about the French Judge and State Aid, and I realize that my presentation will supplement the presentation of Judge Onichor. Just a few words, introductory remarks, before giving you some recent examples of cases dealt by the French Conseil d'État on state aids. So it's not to minimize the role played by national courts in the field of state aid, to start by recalling that its role is limited by the powers conferred on the European Commission by the treaties. And as you know, the Court of Justice speaks of complementary but distinct roles. Thus, national courts may be seized of disputes requiring them to interpret and apply the concept of state aid with a view to determining whether or not a state measure introduced without taking account of the prior control procedure by the Commission should be subject to it, and if so, to order its recovery. However, these courts, as you know, are not competent to rule on the compatibility of the aid measures with the internal market. This assessment falls within the exclusive competence of the European Commission, of course acting acting under the control of the EU courts. However, the relatively limited but also highly regulated jurisdiction of national courts should not conceal the quantitative importance of state-aid litigation before national courts, and namely before French administrative courts. To give you some figures, since the beginning of the year 2000, there have been approximately 3,700 administrative court of first instance judgments, 1,800 administrative court of appeal rulings, so referring to state aid. And as for the French Conseil d'État, which is the Supreme Administrative Court in France, it has issued about 200 decisions dealing with state aids since the years 2000. A final clarification before turning to recent case law. I refer to French administrative courts and not to French courts. And the reason why is because, as you probably know, the organization of administrative justice in France is different from the organization of administrative justice in Romania. Whereas in Romania, of course I'm talking under your supervision, but in Romania there's only one jurisdictional order. In France, we have two, namely the judicial jurisdictional order and the administrative jurisdictional order. This dualism is not unique to France, as you know. It can be found in many EU member states, such as Austria, Belgium, Netherlands, Italy, Poland, Bulgaria, and in Germany, as you probably know, there are five jurisdictional orders, and not only two. Let's turn now to the recent case law. Following the pollution caused by the sinking of the Erika tanker in 1999, the French government took measures in favor of fishermen, consisting of a 50% reduction in the employer's share and the employee's share of social security contributions for a period of 6 months in the year 2000. In a decision of 14th of July 2004, the European Commission found that these measures constituted incompatible aid and ordered the French authorities to recover them. So the Compagnie des Pêches de Saint-Malo applied to the Administrative Court of First Instance to have the collection order issued by French authorities annulled insofar as it concerns the reductions of employees' contribution, not employers' contribution, but employees' contribution, holding that the actual beneficiaries of the reduction in the employee share of social contributions were not the fishing companies, but their employees. And that's why the two courts, the Administrative Court of First Instance and the Administrative Court of Appeal, ruled in favor of the undertaking. But on the appeal of the Minister of Agriculture before the French Conseil d'État, so the Supreme Administrative Court, the Council of State decided to stay the proceedings and to refer the matter to the Court of Justice for a preliminary ruling. And in a judgment of 17th of September 2020, Compagnie des Pêches de Saint-Malo, the Court of Justice ruled that the Commission's decision of 14th of July 2004 was invalid. It's quite rare for the court to rule that the decision of the Commission is invalid in the framework of the preliminary ruling procedure, was invalid insofar as it qualified as state aid incompatible with the treaty, the reduction in employees' contribution granted by France to fishermen. According to the Court of Justice, it's common ground that employees' contributions are not borne by the fisheries undertakings in their capacity as employers, but are payable by the employees. Those undertakings, according to the Court of Justice, are only required to deduct those contributions from the remunerations of their employees on each salary slip with a view to paying them to the competent social security body. Thus, according to the Court of Justice, the measure reducing the employees' contributions at issues remains neutral in relation to the undertakings and their employees, to the undertaking, and their employees are the actual beneficiaries of the reductions at issues. Nevertheless, in its judgment, the Court of Justice didn't rule out the possibility that aid whose direct beneficiaries are the employees of an undertaking may constitute indirect aid granted to the undertaking itself. However, the court noted that neither the contested decision of the Commission nor the file before the court contained any indication that the undertakings concerned had benefited indirectly from state aid. Moreover, it was clear from the contested decision of the Commission that the advantage relied on by the Commission consisted for the undertakings not of an indirect, but of a direct effect. A second case, which is quite interesting, before the French Conseil d'État during the recent years on state aid, it's interesting because the Court of Justice has given very few rulings on amendments to aid schemes already approved by the Commission. And so a case, the SAS Carrefour hypermarket case, was of interest, firstly because of the question referred to the Conseil d'État, to the Court of Justice by the Conseil d'État for a preliminary ruling on this topic, but it was also interesting because finally the court's answer ultimately proved to be of no use for resolving the dispute. Sorry. So the case concerned a film, an audiovisual aid scheme approved by the Commission and financed by three taxes: a tax on cinema tickets, a tax on television services, and a tax on sales and rentals of videograms. In order to obtain reimbursement of the tax on sales and rentals of videograms that they had to pay, several companies, including Carrefour, the very famous hypermarket society, brought an action before the administrative court. These companies argued that the aid scheme in question should have been subject to a new notification to the European Commission insofar as the revenue, the proceeds from the taxes increased considerably between the decision of the Commission and the year 2011 by almost 60%. The revenue from the tax on television services alone, which is payable by television publishers and distributors, rose from 262 million euros per year to 631 million euros, within 7 years. However, while the European Commission authorized the change of the tax base in 2007, its decision was based on much more limited forecast of the increase in tax revenue provided by the French authorities. And the problem for the French Conseil d'État was that there's an article in a Commission regulation of 2004 which provides very specifically that an increase in the initial budget of an existing aid scheme, so authorized by the Commission, shall not be considered to be an alteration to the existing aid if it doesn't exceed 20%. So this time it was 60%, so 20%. Alors, so why the French Conseil d'État decided to refer a question to the Court of Justice in spite of this regulation? And the reason why we decided finally to question the court, we have much debate about that, was that notifications to the commissions are prior in nature. How can the Commission so be notified of an increase in a tax above 20%, financing an aid scheme when this sharp increase, of course, will be noted afterwards, after the fact. Moreover, this sharp increase could be only temporary, just, for 1 year. Should we then wait until this sharp increase is permanent before notifying to the Commission? And another question, it often happens that part of the proceeds of the tax is set aside or deducted for the benefit of the state budget and not so giving to the undertakings. So in this case, should the increase in question be assessed in relation to the proceeds of the tax or in relation to the aid actually paid out? However, in its judgment of September 2018, the Court of Justice stuck to a strict reading of Article 4 of the regulation of the Commission, holding in particular that the 20% threshold is to be assessed in relation to the revenue assigned to the aid scheme and not in relation to the aid actually granted under that scheme to the undertakings. But nevertheless, the victory of Carrefour and its co-applicants was not so certain. Indeed, in its judgment, the Court of Justice first took the trouble to recall its case law, according to which, for a tax to be considered an integral part of an aid measure, there must be a binding link between the tax and the aid concerned, in the sense that the proceeds of the tax are necessarily assigned to the aid and directly influence the amount of the aid. And the court, which in this case have clearly doubts in this respect about the direct link between the tax and the aid, invited the French Conseil d'État to verify its premise that the three taxes in question were an integral part of the aid scheme. And so, a year later, in 2019, after having received the answer of the Court of Justice, the French Conseil d'État, in its final decision, concluded that there was no such binding allocation link, since a significant part of the proceeds of the tax was placed in reserve, and another part was subject to deductions for the benefit of the state budget and was therefore not allocated to the film and audiovisual aid scheme. So in the end, the preliminary question proved interesting but unnecessary. A third case, which is quite interesting, without a reference case to the Court of Justice, but a decision by the French Conseil d'État, it's a decision of 7th of June 2017, Société Le Muselet Valentin. In this decision, for the first time, le Conseil d'État français ruled that the obligation for a company receiving state aid declared incompatible with the internal market by the Commission to repay this aid and pay interest cannot engage the responsibility of the state. It's true, according to the French Conseil d'État, that the French state was at fault for having first paid aid that was subsequently declared incompatible with the common market by the Commission, and also, in this case, for having delayed in recovering the aid and so demanding interest. But because the French authorities delayed the recovery of the aid, and of course the undertaking had to pay interest because of this delay since the granting of the aid. But according to the French Conseil d'État, there's no causal link between the fault of the French authorities and the damage suffered by the company, since by virtue of its EU obligations, France was required to recover the aid and to attach default interest to this recovery in order to compensate for the financial and competitive advantage provided by the aid. And so the solution of this decision of the French Conseil d'État seems to me hardly questionable, since according to the case law of the Court of Justice, as you know, no company, however small it is supposed to be unaware of the law on state aid, and so a company must only blame itself if it has to repay incompatible aid. However, while the company receiving incompatible aid cannot hold the state liable for that, this is not the case, of course, for a competitor of this company, which has suffered competitive damage of the result of the incompatible aid. But the possibility for a competitor of a company receiving an aid declared incompatible with the common market by the Commission, the possibility to effectively challenge the liability of the state or the public authority having granted the aid is a long-standing problem. Also, the Court of Justice and the European Commission have long been calling for this type of action. It must be admitted that it's very difficult for a competitor to demonstrate that the incompatible aid is responsible for a reduction in its commercial activity. However, this possibility of compensatory action has recently become a reality in France in the context of two legal sagas. The first sagas involved for many years two maritime companies providing passenger transport between mainland France and the island of Corsica. This legal saga, which has occupied both the EU courts and the national courts, has opposed the Société Nationale Corse Méditerranée, acronym SNCM, which was a public company because now it's in liquidation, against Corsica Ferries, which is a French company, but with English name, a French company, but which is a private company. By a decision of 2013, the European Commission qualified as state aid incompatible with the common market the financial compensation paid by the Corsican Regional Authority to SNCM for a so-called additional service provided by this company for 6 years, between 2007 and 2013. This additional service consisted of the operation by the maritime company, by SNCM, of 2 car ferries during peak periods between the port of Marseille on the mainland and 3 Corsican ports, but in competition with the lines operated by Corsica Ferries between mainland and Corsica and those ports. Following this decision, the Corsica Ferries companies asked the Administrative Court of First Instance of Marseille to order the Corsican Regional Authority, no, it was not the national state, but the regional authorities, to pay it the sum of 88 million euros with interest as a legal rate as compensation for the damage caused to it by the operation of the so-called additional service for this period, and of course of the aid granted for this additional service. And in a judgment of 2017, which was the first in France of this type, the Administrative Court of First Instance ordered the Corsican Regional Authority to pay Corsica Ferries a sum almost 85 million euros, so a little bit less, but 85 million euros with interest as a legal rate from the granting of the aid in 2014. In particular, the Administrative Court of First Instance considered that the Corsican Regional Authority did not seriously dispute that if the additional service has not existed, so financed by the aid, Corsica Ferries would have been able to improve the capacity of its ships on the routes concerned. In assessing the loss, the Administrative Court of First Instance based itself on the assumption that about 70% of the passengers which used the additional service of SNCM would have switched to the routes operated by Corsica Ferries. So this was the first assumption of the court. And the second assumption was the fact that there would have been the Corsica Ferries company would have been able to absorb this increase in traffic without increasing its fixed cost. And in a judgment of 2021, the Marseille Administrative Court of Appeal, after ordering an expert appraisal to determine the amount of compensation, but finally the Court of Appeal conferred in substance the judgment of the Court of First Instance. But the Corsican Regional Authority lodged an appeal against the judgment, the ruling of the Court of Appeal before the French Conseil d'État. But in a decision of 2021, at the end of the year, the Conseil d'État rejected the appeal of the Corsican Regional Authority against this judgment. So finally, the Corsica Ferry company was given 85 million euros, so for a compensation of the state aid incompatible with the common market paid out to the SNCM. And a second case, a second saga, is a very different saga. In a judgment, so I will go directly to the ruling of the Court of Appeal, but the Paris Administrative Court of Appeal, in a ruling of 2019, ordered the French state, this time it was the French state, to pay the Société Internationale de Diffusion et d'Édition, CID in the French acronym, compensation of 10 million euros for aid paid by the state to the Coopérative d'exportation du livre français, CELF, from 1981 to 2001 for 20 years. The aid had been paid out for 20 years to encourage small orders of books from bookshops located abroad. Because, you know, small orders of books cost a lot, you know, for the publisher. And so there was an aid for 20 years, you know, to encourage, of course, the delivering of these books from to the small bookshops abroad, of course, to encourage, of course, the French language. And as this aid was finally declared incompatible with the internal market by the European Commission, the state, according to the Court of Appeal of Paris, committed a fault likely to engage its responsibility towards CID, which was CELF's only competitor. And in the decision of 22nd of July 2020, the Conseil d'État rejected the appeal of the Minister of Culture against this ruling. So this time it was not 85 million euros, but 10 million euros. So it's also interesting, another procedural topic which is quite interesting, is that the Paris Administrative Court of Appeal, before giving its judgment, had called on the European Commission to provide guidance based on a communication by the Commission of 2009 concerning the application of state aid rules. In this notice of 2009, the Commission states that questions concerning the determination of damages may also be the subject of request for assistance addressed to the Commission by national courts. And this assistance, according to this communication, may take the form of the provision of factual data, statistics, market studies, and economic analysis by the Commission to the national judge. And this power is now enshrined in Article 29 of a regulation on state aid of 2015, which empowers national courts to request the Commission to provide information in its possession or an opinion on questions concerning the application of state aid rules. So, you know, it's a very large possibility. Another detail which is quite interesting is that Article 29 also empowers the Commission to submit on its own initiative written observations to national courts on its own initiative. For a long time, the member states were very reluctant to give this possibility to the Commission. I remember we refused the Commission to submit written observations before national judges. But finally, in 2015, we decided to allow the Commission to do it. So it's quite rare, but at least there's one case in France before the Court of Appeal, Administrative Court of Appeal of Bordeaux, in a case, another saga, the Ryanair saga, state aid, and in 2014-15, the Commission, on its own initiative, submitted written observations before the Bordeaux Administrative Court of Appeal. So, to conclude, which I think is very interesting, is that what is called the private enforcement of state aid is probably at its beginning, but very probably this, what is called private enforcement of state aid, it means not by decisions of the European Commission, but by initiatives of competitors, of course, of the beneficiaries of aid declared incompatible with the common market by the Commission. I'm sure that this private enforcement is set to grow in the coming years. Thank you very much.
And yes, we plan somehow to have a both perspectives somehow on this, in the idea that the next speaker actually has a similar title or a similar approach on this, but with the Romanian side, let's say. So next we have Judge Amelia Onișor from the Bucharest Court of Appeal, also trainer at the National Romanian Institute of Magistrates. I think over there with the subject judicial cooperation in civil matters. And I think it's also about remedies in matters of state aid. So maybe after we'll have a debate between the two jurisdictions.
First of all, I would like to thank you for the beautiful presentation, very thoroughly and detailed presentation. Thank you, and I always have a great interest as an administrative judge, of course, not in the sense of the French legal system, but still an administrative judge in your topic, and also the topic that you have presented, because I have a specialization in public procurement, and it is quite intertwined with the topic that you mentioned. So thank you, and it was a pleasure to be present here. I will switch to Romanian. Is it okay?
Yeah, it's okay to have that, and at the end we can actually see exactly how we can debate on this.
Yeah, sure. And I can conclude in English at the end of the presentation.
Thank you.
Mulțumesc mult pentru invitație. E o onoare să fiu aici alături de dumneavoastră la un eveniment care pare să fie deja de succes. Sunt convinsă că așa se va contura până la final. Voi vorbi astăzi despre remedii în fața instanțelor naționale în materia ajutorului de stat. O prezentare, cred că nu este, nu e foarte clar vizibilă acolo pe ecran. Poate dacă se mai pot face niște ajustări tehnice, să fie zoom out un pic. Dacă nu, cred că ne putem descurca și așa, nu?
Online oricum se vede prezentarea care o aveți, cea de acolo. Da.
Acum e mult mai bine. Mulțumesc. Abordăm niște principii generale la început, pentru că e foarte important să avem o imagine foarte clară în ceea ce privește competențele pe care le împart Comisia, instanțele naționale, și, pe de altă parte, și Curtea de Justiție. Vom avea o discuție și în legătură cu competențele pe care le are Curtea de Justiție în acest domeniu. Comisia are această competență exclusivă de a aprecia, în primul rând, asupra notificării măsurilor care pot constitui ajutor de stat înainte de implementarea lor de către statele membre, deci o apreciere ex ante pe care o face doar Comisia. De asemenea, apreciază asupra compatibilității ajutorului de stat cu piața internă, în temeiul articolelor 107 alineatul 2 și 3 din TFUE și 106 alineatul 2 din același tratat. Analizează și investigează plângerile pe care terții le pot formula în legătură cu ajutoarele de stat ilegale și incompatibile cu piața internă. Există de asemenea și niște competențe partajate între Comisie și instanțele naționale. Ambele pot aprecia asupra calificării măsurilor de stat ca fiind ajutoare de stat în temeiul condițiilor prevăzute la 107 alineatul 1 din Tratatul privind funcționarea Uniunii Europene. Sunt acele condiții pe care le cunoaștem cu toții și care sunt analizate atât de Comisie cât și de instanțele naționale, dar și de Curtea de Justiție atunci când face o analiză în privința ajutoarelor de stat, de exemplu atunci când interpretează articolul 107 alineatul 1 în temeiul unei cereri de trimitere preliminară. Mai precis, se verifică dacă este vorba despre o întreprindere, noțiunea de întreprindere însăși are un sens autonom, dacă există un avantaj economic în favoarea unei astfel de întreprinderi, avantajul este acordat de stat sau prin intermediul resurselor statului și dacă acest avantaj este selectiv, un lucru foarte important pentru toată această apreciere a noțiunii de ajutoare de stat. De asemenea, iarăși o chestiune extrem de importantă dacă ajutorul de stat are consecințe asupra concurenței din piața internă. De asemenea, atât Comisia cât și instanțele naționale analizează împrejurarea dacă măsura trebuia să fie notificată sau nu. Avem un bogat soft law aici, s-a făcut referire mai devreme și în legătură cu acele comunicări ale Comisiei. Comisia are mai multe comunicări interpretative în domeniul acesta al ajutoarelor de stat și chiar și cu comunicare în ceea ce privește rolul instanțelor naționale, o comunicare destul de nouă, din 2021. Am contribuit puțin și eu la acea comunicare, în sensul că am fost reprezentantul României în cadrul dezbaterilor avute de comisie pentru, de fapt, îmbunătățirea unei forme mai vechi a acelei comunicări interpretative. În privința instanțelor naționale, ele au, de asemenea, o competență exclusivă în anumite domenii, cum ar fi în legătură cu remediile și cererile de despăgubire ale terților afectați de punerea în aplicare a unei măsuri de ajutor de stat și ele pot decide asupra suspendării măsurilor legale sau recuperarea ajutorului de stat, indiferent dacă acest ajutor de stat este sau nu compatibil cu piața internă. Ceea ce este esențial este să fie considerat ilegal. De asemenea, există posibilitatea ca instanța națională și, de fapt, doar instanța națională poate să ia măsurile provizorii pe care un terț le poate solicita într-un caz dat. Poate o instanță, de asemenea, să dispună acordarea de despăgubiri în favoarea terților, în special competitorilor beneficiarilor de ajutoare de stat. Aceasta este tabloul competențelor partajate între Comisie și instanțele naționale. Faptul că Comisia Europeană are competență exclusivă de a se pronunța asupra compatibilității unui ajutor de stat cu piața internă, o știm dintr-o jurisprudență care este constantă și care a început cu mult timp în urmă, până în zilele noastre, aș zice. Această cauză, care este relativ recentă, are mai puțin de un an, e o cauză care privește noțiunea de ajutor de stat nou. Ce înseamnă ajutor de stat nou? Atunci când avem deja o schemă de ajutor de stat care a fost deja aprobată de către Comisie. În cauză era vorba despre niște microcentrale hidroelectrice de folosire individuală. Și se punea problema dacă, în momentul în care a expirat acea schemă de ajutor de stat și în măsura în care statul național menținea acele măsuri favorabile pentru anumite întreprinderi, putem considera că acel ajutor este un ajutor existent sau este un ajutor nou. Și Curtea de Justiție a precizat că este, de fapt, un ajutor nou. El trebuia notificat, din nou, ceea ce nu s-a întâmplat în cauză, dar cu ocazia acelei analize a reamintit Curtea acest principiu foarte important, că e de competența exclusivă a Comisiei să aprecieze compatibilitatea unor măsuri de ajutor de stat cu piața internă, în timp ce instanțele naționale asigură protecția drepturilor justițiabilor în cazul încălcării obligației de notificare prealabilă la Comisia Ajutoarelor de Stat. Instanțele, CJUE, că vorbeam puțin mai devreme despre acest lucru, are, bineînțeles, niște competențe care îi sunt atribuite prin tratat și sunt destul de clare. Analizează acțiunile directe care pot fi îndreptate împotriva, de exemplu, deciziei de constatare a unui ajutor ca fiind ilegal și incompatibil cu piața internă. În temeiul 263 din Tratatul privind funcționarea Uniunii Europene, evident, acest lucru se întâmplă în primă instanță de către tribunal, analiza se face de către tribunal și recursul la Curtea de Justiție. De asemenea, în temeiul acelei proceduri a trimiterii preliminare, dacă există un proces care să fie pendinte în fața instanțelor naționale și dacă se pune problema validității deciziei Comisiei în legătură cu ajutorul de stat, evident, instanța națională nu are competențe în acest sens și știm asta de la Fotofrost încoace și atunci, dacă există un astfel de dubiu, trebuie ca instanța națională să sesizeze, indiferent de gradul său, să sesizeze Curtea de Justiție pentru a se pronunța asupra validității deciziei. De asemenea, CJUE interpretează noțiunea de ajutor de stat atunci când este sesizată de instanțele naționale în același temei, 267 din tratat, dar, bineînțeles, e vorba aici de trimiteri preliminare în legătură cu interpretarea unei norme de dreptuie. Este clar, așa cum precizam mai devreme, că și instanțele naționale au această posibilitate de a analiza noțiunea de ajutor de stat atunci când vom vedea, sunt puse în fața unei acțiuni, de exemplu, de despăgubiri pentru că s-a încălcat obligația de standstill. Pentru instanțele naționale, decizia Comisiei este obligatorie în ceea ce privește evaluarea cu privire la existența unui ajutor de stat. Instanțele naționale trebuie să se abțină de la pronunțarea unei hotărâri contrare unei decizii a Comisiei. Evident, ele au marja de apreciere de a formula o trimitere preliminară în temeiul articolului 267 din TFUE, cu cele două distincții referitoare la interpretare versus validitate, în sensul că la validitate, atunci când există un dubiu, trebuie mult necesar să sesizezi Curtea de Justiție. Altfel, dacă ești instanță de ultim grad și ai astfel de dubii, iarăși ești obligat, o obligație care nu este absolută, după cum știm din jurisprudența de la CILFID până la Consorțiul Italian Management. M-am gândit să împart, practic, aceste remedii și analiza în sine a remediilor în fața instanțelor naționale în funcție de cele două ipoteze, dacă avem o decizie a Comisiei sau dacă nu avem o decizie a Comisiei. Dacă Comisia a emis o decizie prin care a declarat ajutorul ca fiind compatibil, aceasta nu înseamnă că ex post facto s-a regularizat ajutorul în sine, măsura de punere în aplicare a ajutorului, pentru că, în principiu, s-a încălcat această obligație de notificare care era obligatoriu de realizat în cazul dat și, prin urmare, de exemplu, pentru recuperarea prejudiciului în urma încălcării acestei obligații de standstill, este posibil să se facă o astfel de analiză. Curtea de Justiție, în cauza care a fost discutată puțin mai devreme, Self, referitoare la acel ajutor, acele măsuri acordate unei societăți franceze în legătură cu broșurile, cărțile pe care le trimiteau în străinătate pe bani destul de puțini, aveau nevoie de o susținere din partea statului și această măsură a fost analizată de Curtea de Justiție. Curtea de Justiție a precizat că decizia finală a Comisiei nu are drept consecință a face conforme cu legea a posteriori actele de executare care nu erau valide, pentru motivul că fuseseră adoptate cu încălcarea interdicției prevăzute la acel articol. Și ați aflat deja că litigiul era destul de complex, Comisia a analizat deja a treia oară această chestiune. Oricum, concluzia era în sensul pe care l-am prezentat-o anterior, că faptul că e compatibil un ajutor de stat nu înseamnă că nu s-a încălcat acea obligație de standstill, prin urmare nu există un prejudiciu care trebuie să fie acoperit. La fel și în Arriva Italia și alții, li se amintește instanțelor naționale că obligația de a avea în vedere toate consecințele unei astfel de încălcări în conformitate cu dreptul național, atât în ceea ce privește validitatea actelor de punere în aplicare a măsurilor de ajutor, cât și recuperarea asistenței financiare, este foarte importantă. În ipoteza în care avem o decizie de inițiere a procedurii, deci nu o decizie care să analizeze compatibilitatea ajutorului de stat încă, ci doar o inițiere a procedurii și procedura este pendinte la comisie, instanța națională nu poate considera că această măsură nu constituie ajutor de stat, nu poate să mai facă o astfel de analiză câtă vreme s-a demarat această procedură de către comisie și ea poate decide fie să suspende punerea în aplicare a măsurii în cauză și să dispună recuperarea sumelor deja plătite, fie să ia niște măsuri provizorii pentru a asigura protecția intereselor părților în cauză, evident și eficacitatea deciziei Comisiei privind inițierea procedurii. Ceea ce nu se poate face, și acest lucru este clar determinat, nu se poate suspenda cauza. Ești sesizat cu o cauză, de exemplu, ca instanță națională, în legătură cu repararea prejudiciului cauzat ca urmare a încălcării obligației de standstill. Nu poți suspenda cauza până când se pronunță comisia cu privire la natura ajutorului. De ce? Pentru că aduce atingere în felul acesta drepturilor terților în principiu și asta ni se spune și în această cauză SELF. Este foarte comod pentru instanțe nu să suspende o cauză și să aștepte acest lucru, pronunțarea, de către comisie cu privire la compatibilitate, dar este complet interzis, aș zice, și produce la rândul său prejudicii terților. În ceea ce privește ipoteza a doua, absența unei decizii a comisiei, instanța va trebui să analizeze propriu motu, practic, cele trei chestiuni. Unu, dacă acea măsură îndeplinește condițiile pentru a fi considerată ajutor de stat și analizează potrivit interpretării date articolului 107 alineatul 1 din TFUE în jurisprudența CJUE în special. Dacă acea măsură face obiectul obligației de standstill, pentru că sunt niște exceptări, cum ar fi în privința ajutoarelor de minimis, de exemplu, dacă vorbim despre ajutoare, măsuri acordate de cel mult 200.000 de euro pe parcursul la 3 ani, cu privire la aceeași întreprindere, atunci această obligație de standstill practic nu există în legătură cu măsurile respective. De asemenea, trebuie să ia măsuri și să cerceteze, dacă e cazul, să ia măsuri corective adecvate pentru a asigura protecția drepturilor terților afectați de o astfel de încălcare. Ajutor nou, am vorbit puțin mai devreme ce înseamnă în contextul acesta când acorzi un ajutor pe o anumită perioadă și după expirarea schemei aprobate, dacă le acorzi în continuare, e vorba tot despre un ajutor nou care trebuie notificat comisiei. De asemenea, modificarea unui ajutor existent este tot un ajutor nou, pentru că atunci când a făcut o analiză comisia asupra compatibilității, a luat în considerare toate elementele care sunt proprii acelei măsuri și dacă ai schimbat ceva, care era esențial, evident, o nouă analiză trebuie realizată de către comisie. Ziceam despre ajutoarele de minimis care sunt exceptate și mai există și exceptări pe categorii. Acum, în perioada pandemiei, au fost foarte multe exceptări în această privință, care nu sunt sau nu trebuie să urmeze această cale a notificării. O decizie de la Înalta Curte de Casație și Justiție în legătură cu aceste noțiuni și ceea ce înseamnă, de fapt, ajutor de minimis, obiectul acțiunii era anularea deciziei de recuperare a unei sume care era superioare valorii de 200.000 de lei, cred că era euro, de fapt, și era vorba despre niște măsuri acordate de Centrul Național al Cinematografiei. Tot această instituție a emis o decizie pentru a recupera sumele respective, pentru că a constatat că, de fapt, pe parcursul celor 3 ani fiscali cu privire la acea întreprindere a fost acordată o sumă care era superioară valorii maxime pentru ajutoare de minimis. Ei, în instanță, au contestat și acest lucru, că n-ar fi putut chiar instituția, organul care a acordat acel ajutor de stat prin unilateral, practic, să decidă recuperarea ajutorului pe care tot ea l-a dat. Însă, în Alta Curte de Justiție a spus că este perfect realizabil acest lucru și, de altfel, e chiar o obligație pe care o are o astfel de instituție să recupereze sumele avansate. Acțiunea a fost respinsă, prin urmare, a fost o acțiune în contencios administrativ, pentru că depășea acel prag de minimis. Mai am puțin timp? Sau? Ok. În privința obligației de standstill, o altă hotărâre de la Curtea de Apel Constanța, de altfel, aici au fost mai multe hotărâri în același domeniu, referitor la la despăgubiri solicitate pentru pretinsa încălcare a obligației de standstill privind organizarea serviciului de pilotaj al navelor maritime și fluvio-maritime. Aici, instanța analiza, practic, dacă sunt îndeplinite cerințele de la 107 alineatul 1 din TFUE, dacă sunt toate elementele ajutorului de stat prezente cu privire la acele măsuri și a constatat că nu, în mai multe rânduri, în mai multe cauze similare, ziceam, pentru că, de fapt, acel serviciu nu ar afecta concurența pe piața liberă, ar fi fost ceva ce ținea de monopolul statului, nu era deschis pieței libere. În ceea ce privește, de fapt, doar să concluzionăm, în faptul că instanțele naționale trebuie să le ofere justițiabilor certitudinea că vor fi luate toate măsurile corespunzătoare în conformitate cu dreptul lor intern și ceea ce mi se pare extrem de important este acest lucru legat de autonomie procedurală. Putem să facem tot ceea ce este permis în dreptul nostru național, în special în dreptul, de fapt în dreptul procedural, dar cu cele două limite, să nu aducem atingere eficacității dreptului Uniunii Europene și nici principiului echivalenței, în sensul că să nu acordăm mai puține drepturi sau drepturi care sunt restrânse în comparație cu cele care derivă din dreptul național, pentru că acestea sunt drepturi care derivă din dreptul Uniunii Europene și trebuie să existe o balanță între, inclusiv între pârghiile procedurale care sunt recunoscute pentru ambele, pentru drepturile din ambele surse. Mulțumesc mult! I can conclude also in
Yeah,
English.
yeah, just to connect this one with the other presentation, if possible, yeah.
Okay. So, what I have stated here, it is related to the remedies that the national courts can take related to the state aid, and we have seen a lot of cases from the Court of Justice of European Union, also the case that you mentioned, the SELF case, because it is quite interesting and important in all this matter of state aid. And also we had several national cases related to the analysis that the national courts have made regarding the concept of the state aid based on Article 107, paragraph 1 from the Treaty of European Union, functioning of European Union. So the national courts, actually in Romania, we don't have, a very large case law related to this problem, because in general, the parties are quite skeptical formulating actions before the Commission state about this state aid, if it is compatible or not with the internal market. But nowadays, I think we have 2 or 3 years since we, at least at the Court of Appeal in Bucharest, but also in Constanța and some other courts, that we have dealt with such cases. And in general, I think in 90% of the cases, the problem related to the interpretation of the notion of the concept of state aid appears. So, and the national courts just do that, ask the Court of Justice to interpret the notion when they deal with such cases, even though they are not judging in the last instance, because in Romania, the Court of Appeal can judge in first instance in administrative cases related to the decisions, for example, from certain bodies or institutions from our country. And in the end, we have stated, especially related to the procedural autonomy, that we have to be very careful to give all the parties all the rights that derive from EU law, taking into consideration the two limits of procedural autonomy. Thank you so much.
Thank you. Now, some other conclusion, those two, or any questions? Is it okay? Now, because we have a break and have 20 minutes left, we should actually get to the last presentation. We have here present Mr. Laura Lițu, Cabinet Director at the Government Agent for the European Court of Justice Office. And she has a degree in international law and a complex activity in matters of EU law, tax and competition. And today area it's related on this aspects. Thank you for coming at our conference and offering again on these sites, on these issues, your opinions. I think also the presentation is in Romanian, yeah?
I will try to speak in English. I think
okay.
I can try that. Thank you so much for inviting me and for the introduction. Indeed, I will try to touch upon a recent case law of the CJEU in a request for preliminary rulings referred by Romanian national courts in the field of tax law and competition, but I will try to steer clear of state aid. As mentioned in the presentations before, the preliminary ruling is a mechanism provided by Article 267 of the Treaty on the Functioning of the European Union, TFEU, which in essence allows national courts, when they deem that an interpretation of EU law is necessary for them to solve a dispute brought before them, it allows them to ask the CJEU the relevant question. In both fields, which I will be touching upon today, the CJEU's case law is quite rich, as you could have probably have already seen, and especially in tax law, which is responsible for about 30%, I believe, over the past years of the total of CJEU rulings in preliminary rulings. So, to start, I will briefly approach a very recent judgment that the court released 2 weeks ago on the 2nd of March in case C-394 of 2021, Bursa Română de Mărfuri. Just a moment, please. The national litigation, which gave rise to this case that touches upon both energy law and competition. I will try to be briefer on the energy part. Concerned the refusal by the National Regulatory Authority in the field of energy to issue a license to Bursa Română de Mărfuri, a company integrated in Romania, to issue a license for it to organize and operate centralized electricity markets. This refusal was based upon a national legislation which is no longer in force in Romania. Article 10, paragraph 2, letter F of Law 123 of 2012 on electricity and natural gas, which provided that the competent authority will only issue one electricity license, operator's license. So when that law entered into force, there was a company in Romania, Opcom, that already had a license issued in 2001 for 25 years. Therefore, it had the monopoly on electricity markets in Romania. in this context, actually it had the monopoly on intermediating offers to sell and bids to buy electricity on short-term, medium-term, and long-term markets, or to use the phrasing in a relevant EU law, intraday, day-ahead, and forward markets. This, just so everybody understands the words that I'm using. In this context, the referring court asked 3 questions to the CJEU. The first 2 regarded electricity, especially if the relevant EU provisions, Regulation 943 of 2019 on the internal market for electricity precluded a national legislation such as the one that I just described. The CJEU said that as regards the first 2 markets, meaning day-ahead and intraday market, no, the regulation does not preclude practically maintaining a national legal monopoly if that legal monopoly was enforced on the date of entry into force of a different EU regulation, Regulation 1222 of 2015. Or in 2015, when this entered into force, Opcom already had its legal monopoly, so everything was fine on this side. As regards the third market, the forward market, regulation, according to the court, Regulation 943 does not preclude, again, maintaining such a legal monopoly, but it would have to be analyzed also in relation to primary EU law, so the EU treaties. Now, the third preliminary question is the one that touched upon the area of competition, and namely if Articles 101, 102, and 106 of TFEU precluded the type of national legislation that I just described. The CJEU firstly clarified that this issue does not arise for the first 2 types of markets, intraday and day ahead, because since Regulation 1222 already allowed for maintaining the monopoly, there could be no competition problem in this area. So the third question should be only analyzed as regards the forward market. Right here, the CJEU felt the need to recall its constant case law that it's necessary for the referring court to clarify the factual and legislative context that gave rise to its question. It emphasized that in the area of competition, which is characterized by extremely complex factual and legal situations, it is of utmost importance, or even more important, if I could phrase it like that, to give all the details. And in this case, the request for preliminary ruling did not contain any indication as to what had prompted the court to refer this question. It did not state why Articles 101, 102, and 106 would be applicable in this case, or why a national legislation like the one we are discussing could infringe those articles. Right here, I would feel the need to make a personal comment. I do not think I can imagine right now off the top of my head a hypothesis where a company that has monopoly, so is alone in a certain market, could collude with a different company so as to make Article 101 of TFEU applicable. But as regards the other 2 articles, 106 read in conjunction with 102, there was already case law of the Court of Justice stating that these 2 articles presuppose that there should be a dominant position on a significant part of the internal market. There should be an abuse of that dominant position, and an abuse in such a manner that is liable to affect trade between member states. So, because none of these elements could be found in the request for preliminary rulings, especially in this specific area of competition, the CJEU had to declare the question inadmissible. Now, going forward, I would like to change the field a bit and talk about case law very recent case law in tax law area, and especially the reverse charge mechanism. It's case C-146 of 2021, Direcția Generală Regională a Finanțelor Publice București, which is essentially the name of a tax authority in Bucharest. So what was the national litigation that gave rise to the preliminary question in this case? Essentially, a tax authority inspected VB, a company selling timber in Romania, and required it to make a retroactive payment of a value-added tax, VAT, and refused to apply the reverse charge mechanism. The reason for this refusal was that the company VB had not registered prior to making the taxable operations, had not registered for VAT purposes, even though she had exceeded for some time the ceiling, the threshold, under which small businesses were exempt from this obligation. In this context, I think it would be all right to clarify a bit the relevant EU and national law in this field. Article 193 of the VAT Directive states the rule that the taxable person who is liable to pay VAT is the one selling goods or providing a service. This is the rule. Now, Articles 199 and 199 letter A of the same directive provide certain fields where it is possible for member states to derogate and to adopt this reverse charge mechanism, where the taxable person paying VAT is actually the beneficiary, the one receiving the goods or services. Now, the sale of timber was not among these areas. However, there's also Article 395 of the VAT Directive, which allows the EU Council to authorize any member state to derogate from provisions of the VAT Directive insofar as it is necessary to simplify procedures of collecting VAT and to avoid certain forms of tax evasion and avoidance. So, taking into consideration this article, upon request of Romanian authorities, the EU Council issued in 2010 a decision allowing Romanian authorities to have a derogation from the general rule in the VAT Directive and actually include in the reverse charge mechanism the sale of timber, the supply of timber. This is exactly what national law did by Article 160 of the former tax code, which would now be 331 of the tax code entered into force in 2015. The only condition mentioned there is that both taxable persons, the buyer and the seller, need to be registered for VAT purposes. So this is the context in which the National Court decided to refer a question to the CJEU, asking if the VAT Directive and the principle of fiscal neutrality precludes national legislation under which the reverse charge mechanism cannot be applied if the taxable person selling the products was not registered, had not applied or obtained of its own initiative registration for VAT purposes before the taxable operations. The Romanian authorities were not sorry to see the decision of the CJEU that EU law does not preclude such legislation, and I will briefly present the three main pillars on which the court based its decision. Firstly, the court saw that neither the VAT Directive nor the Council decisions establishing that Romania can introduce derogations from the VAT Directive contained any mention that Romania could not establish the mechanisms, the concrete mechanisms for the application of this exceptional mechanism of reverse charge. Actually, because it is an exceptional mechanism, it should be subject to strict interpretation and application. Therefore, the national legislation, because it's clarified and limited the scope of application of this mechanism, it was perfectly valid from this point of view as regards EU law. Secondly, the court admitted that in its previous case law in the field of VAT deduction, that's different a bit, it had stated that the condition of registration is purely formal, and it should not, if it is not met, that should not preclude a right of deducting VAT so long as the material conditions for a right to deduction are met. However, with the occasion of this new case law from June 2022, the court clarified that its former case law actually sought to ensure compliance with the principle of fiscal neutrality by requiring that the taxable person may deduct input VAT if the material conditions were met. So the right of deduction of the recipient of the supply or the beneficiary must be in principle in the same way respected in the reverse charge mechanism and in the common VAT system. So that right is not affected for the beneficiary if tax authorities refuse to the provider the application of the reverse charge mechanism. Because a refusal to apply this mechanism does not undermine the right to deduct VAT for the beneficiary, it does not undermine the fiscal neutrality. So everything was also golden on this side. Thirdly and lastly, the court recalled that the principle of fiscal neutrality is essentially a translation in the field of VAT, of tax law, of the general principle of equality of treatment. So that similar situations should not be treated differently unless such a difference in treatment is objectively justified and pursues a legitimate aim and is proportionate with that legitimate aim. So in this respect, the CJEU could only find that the criterion used was objective. All companies, regardless if they were sellers or buyers, were subject to the obligation of registering for VAT purposes. The aim of the restriction was legitimate. It was linked to legal certainty and legal clarity in a context where the Romanian timber market consists of an extremely large number of small businesses, which the Romanian authorities would otherwise have found very difficult to control. And also, by imposing on taxable persons a condition of registering for VAT purposes, the beneficiary of the transaction finally has an accessible criterion for knowing precisely the extent of obligations of their co-contractor and their own obligations, their own tax liabilities. Finally, the difference in treatment thus appears proportionate to the aim pursued, given that anyway registration for VAT purposes is derives from EU law itself, from Article 214 of the VAT Directive, and of course the right of deduction of the taxable persons in question is not called into question itself. So this being said, because I know we don't have much time to discuss any other case law, I will just say that for other recent cases, we publish on a monthly basis on the website of the Ministry of Foreign Affairs synthetic documents containing summaries of the most important or most interesting decisions of the CJEU of the past month, not only in references for preliminary rulings from Romanian courts, but also in different other types of cases. And they are usually grouped by relevant fields so that any interested person can go straight to the area of law that they're interested in and see what is new in the case law. This document is in Romanian, so for those interested of seeing other language versions, more recently the court itself has started publishing, let's call them monthly case law digests, which are also an interesting read. And one final thought. Of course, we have many pending cases right now before the courts, the EU courts, many preliminary rulings. Yes, in the area of tax law, regarding the ways of refunding car taxes that were deemed incompatible with EU law. Also in the area of competition, linked to the extension of concession licenses for exploitation of mineral resources, and in many other fields, consumer protection, etc., etc. Of course, they are still pending before the court, so I could not touch upon them today. But in a few months' time, the judgments will be available to the public, and I'm certain that they will be very interesting talking points the next time we meet, perhaps in a conference similar to the one we are attending today. Thank you very much until then for your patience and your attention.
Thank you. Now, because we have to end somehow, but I think I can address a question to all related to a debate, and I'll start with the construction law and going to state aid and a little bit to tax facilities. Just to touch a bit of that. It's a debate after the war anyway, and after the pandemic in construction field, we had to come and offer some facilities in order to adjust contracts. We had different acts over there, actually two ordinances, and it's debate if any this considered as a state aid, and also, as I know, it's in the rehabilitation program anyway to be refixed. If you have any thoughts on this on the evolution taken into consideration, that will have actually a reaction in the market, and we're in the Bucharest University of Economic Studies anyway, without giving us too many hints anyway. Now I'm addressing the Romanian persons that are invited, but also anyway, if you have any thoughts on this, in the idea of impact of the pandemic, and of course of the war in this specific industry, because clearly with Ukraine being a main supplier of steel over there and others, that was an issue.
The only thing that I can say now, unfortunately, because I'm not linked to the policy making, I'm just part of the team of lawyers who ensure the Romanian government's representation whenever issues, interesting debates arise before the Court of Justice. I can say that in our area of activity, we have not yet seen major changes as regards the types of cases, the types of situations, the concrete measures adopted by member states in this times marked by new challenges. As our colleagues have said in the first presentation, Ms. Chantal Muldealba mentioned that law usually follows what happens in practice, and as far as new law and interpretations of new law by the CJEU, I'm afraid it at this stage, it has not reached such an advanced point. Any novelty has not reached my area of activity.
Thank you. Yeah.
Okay, so it's very interesting because I talk about giving money, helping companies, and you spoke about how to claim companies who are aid. No? So as Ovidiu said, it's like a contradiction, and probably you will have work with all these aids that are going to be given, because maybe some companies will consider that it's not fair and it's going against the European market, no? So let's see what happens, but there's a field of work, I think.
Thank you, Chantal. Now we have a short break in order to switch from this opening session to the, how we call it, academic forum. So some scholars who are coming here and lawyers who are coming here and present some papers in different matters of European business law. Thank you very much. I thank all the guests from abroad and from Romania, and I hope to see you soon in other of our events. Thank you.
My name is Roxana Chiriac. I am a lecturer in the Faculty of Law of the academic Bucharest University of Academic Studies. And I will be your host and moderator for the next panel of our session. First of all, I would like to thank everyone present, as well as everyone who is attending this, this conference online here with us. Also to thank our partners and the faculty for organizing this, this conference. I think some other guests will be joining us later on, but for now, I would like to give the floor to Ms. Laura Nae, legal advisor, who will be here with us presenting an article called Covering the Financial Risks of Companies in the HoReCa Field Through Insurance Contracts and Methods of Alternative Dispute Resolution for these contracts. Thank you, Mrs. Nae, for being here with us. I know that you have written this article alongside Professor Crânguța Leaua, and thank you very much for being here with us today and for sharing with us your work. So you have the floor. I think you can also share the screen if need may be, and thank you very much.
Bună ziua tuturor! Mulțumesc și eu pentru prezentare și sunt foarte încântată de participarea la această conferință. O să încerc o scurtă prezentare a articolului de astăzi, elaborată împreună cu doamna profesor Crânguța Leaua, în engleză, limitat timpului disponibil, bineînțeles. So I will try to make a short presentation of the article for today to fit in time. The article is named Covering the Financial Risk of Companies in the HoReCa Field Through Insurance Contracts and Methods of Alternative Dispute Resolution for this type of contracts. First of all, I would like to say that the term of HoReCa is an abbreviation for the following words: hotels, restaurants, cafes, cafeterias, canteens, being used mainly in Europe, in the Scandinavian and Benelux country, and also in France. In the hotel field, we encounter business management risk, which consists of unforeseen events that intervene unexpectedly and affect the business, revenues, and performance of a hotel. These cases statistically inherently occur after a certain number of years of normal operation of a hotel and may have a greater impact if they occur after the hotel has been recently opened or renovated before the investments in question have amortized. Within the management risk, there are three large categories of situations that can cause financial losses for the owner of the hotel. First, situation of financial losses resulting from the destruction of building and goods caused by events of the nature of force majeure, like earthquake, floods, fires. Second, situation likely to attract financial losses resulting from the civil liability of the hotel owner, with the consequence of compensation that must be paid by him to the damaged person, who may be the hotel's customer or third parties. And third, a situation likely to attract financial losses in the commercial activity of the hotel owner, regardless of his fault, such as situation of force majeure events. Here you can also find the financial losses borne directly by the owner, independent of any contractual relationship, but also the situation where, although here there is a contractual relationship, the risk allocation within it causes the financial loss to be distributed to the hotel owner. From this last category, a very current example was the COVID-19 pandemic, and that's why in the recent years within the hotel industry, the degree of hotel occupancy as well as the average daily rates of accommodation decreased the pandemic affecting the hotel activity all over the world and including Romania. So the hoteliers reanalyzed the type of clauses in the contracts on the basis of which they operated in order to identify the mechanism by which the risk was allocated or possibly insured. Thus, the clauses regarding the exemption from liability for cases of force majeure, the possibility of unilateral termination, the allocation of a risk from the perspective of the principle of contractual solidarity, and accordingly were mainly considered, especially the insurance contracts of this risk. In the following, we'll refer to the insurance contracts related to the type of risk in the hotel field, as well as the other methods regarding them. The general regulation of insurance contracts in Romanian law suitable to HoReCa field can be found in the provision of the Romanian Civil Code and also in the law regarding the authorization and supervision of insurance and reinsurance activity, as well as those of all regarding the insurance distribution. At the same time, insurance and reinsurance regulation can be also found in the European Union legislation, which complementing the provision of national legislation. In the case of the hotel insurance contract, depending on the insured risk, the insured may be the owner of the hotel business, the contractor may be the hotel management company or the hotel operator concluding the insurance contract, and the fourth-party beneficiary can be the consumer. The insurance contractor is the person who concludes the insurance contract in order to insure a risk regarding another person or for his goods or activities. Insurance have designed various insurance contracts to take into account the risk that may arise in the HoReCa with a negative financial impact on the property of the owner of the hotel unit. The three main type of risk in this case are general risk insurance, civil liability insurance, and business interruption insurance. We will talk further, especially about the business interruption insurance. So this kind of insurance insures the financial losses resulting from the risk of interruption of commercial activity caused by the occurrence of contractually defined events from the category of those independent of the will of the parties or certain third parties, which may affect the insured patrimony. In other words, they represent the risk that cannot give the hotel owner the possibility of filing civil liability action against a specific person and recovering the damage in this way. Also, the insurance covers the additional expense of restoring hotel activity, namely the indirect losses resulting from material damage or the restriction of the hotel activity caused by uninsured risk. The insurance can include, for example, cases of pandemic occurring at national and international levels, such as COVID-19. And in this situation, claims regarding losses resulting from this type of insurance will be considered and determined by, in accordance with the express and precise wording of the relevant insurance provision within the insurance policy, and also based on the relevant individual facts results from each individual request. In practice, such insurances can sometimes also cover the situation where there is a possibility of recovering the damage from a party, in which case the insurance company, with the payment of the compensation, is subrogated to the rights of the owner of the hotel against the guilty third party having the right of recourse against him. The compensation in this case of insurance contract covers the loss of profit, the impossibility of realizing benefits by the hotel owner due to the interest event, up to the level of the limit established conventionally with the insurer called insured amount. The emergence of the COVID-19 pandemic has caused large social, as you know, social and economic disturbances with negative effects on traders' activity, which has also led to substantial financial losses in businesses. The majority of insured persons, including those in the HoReCa field, have made claims to insurers for the loss of business interruption related to the pandemic regarding their business interruption insurance policies. In this regard, international statistics are too recent to be made public for now. However, the insurance supervision institutions have tried to make a statistical data that they could collect more transparent in order to require the insured to take advantage of their rights in the best time for business recovery and to avoid the interruption of limitation periods, the prescription terms. Thus, in the case of the United Kingdom, for example, the Financial Conduct Authority has published a number of data regarding business interruption insurance without business interruption claims for the period 2021-2022 regarding the perception of insurance companies affected by the evolution of their insurance requests in the context of COVID-19 pandemic. From these statistics, even if territorially limited to the UK, it follows that the business interruption insurance mechanism has proven its effectiveness. Thus, a number of HoReCa companies have been compensated. However, compensation was awarded for relatively small amounts compared to the impact of business interruption. This fact may lead to the hypothesis that it's possible either that the insured companies did not correctly assess their risk and insured themselves for lower amounts than they would have needed, or that the insurance companies they awarded lower amounts than requested, which would signal potential for future litigation disputes for differences in an unawarded compensation. So, from the perspective of disputes that may arise in the HoReCa field, they can be divided in one, B2C, business to consumer disputes, in which the dispute takes place between the HoReCa service provider, who may be the owner of the HoReCa unit or the hotel operator on the one hand, and the consumers of these services on the other hand, or business B2B, business to business disputes, in which the disputes take place between the owner of the HoReCa unit and the other commercial companies with which he enters into relations commercial, such as franchisor, hotel service operators, wholesalers, suppliers, consultants, and insurance. The general analysis of the advantages of out-court disputes resolution differs according to the categories above. Disputes arising from the contracts concluded between HoReCa owners or operators and insurance companies fall under the category of B2B disputes and may have a national or international component. So, in conclusion, companies in the hospital industry, in the HoReCa field, have recently faced an increase in the demands of customers in a context of constantly involving legal regulation regarding the observance of consumer rights, as well as pandemic situation, as I mentioned before. In this sense, to help develop business in the field and face the challenges of this big industry, the role of the insurance system is in reducing the financial risk of the hotel companies, both in the B2B and B2C relationship, is of particular importance. Taking out an insurance policy in the HoReCa field, and especially business interruption insurance, increases the credibility of the hotel business. Thus, confidence is comfort in the identification of beneficial solutions to protect the hotel business and implicitly in the continuation of contractor relations between providers and the beneficiaries of the HoReCa services. In this regard, the collaborators, the beneficiaries of HoReCa services are aware of the fact that they are working with a partner of an insured business, and the business partnership relation is protected. At the same time, in order for the contractual effects of insurers to prove their effectiveness, they must not be blocked by disputes between the parties, which are time-consuming and human resources, both for them and for the state institutions also. In this context, the alternative dispute resolution methods have a significant role in the quick and low-cost resolution of the possible disputes between the parties, thus ensuring the necessary flexibility, predictability, efficiency, and confidentiality compared to what is possible within the judiciary states. This was my work. Thank you very much. If you have any questions about it, please ask me.
So thank you, Ms. Nye. Thank you so much for your presentation. I think it was very comprehensive as well as it was detailed and very nicely explained, especially how you showed us the different types of insurances, the different types of disputes that can rise in between participants to this economic transaction. So I would like to ask if there are any questions as well. No, then I think that your presentation was extremely comprehensive. So thank you very much. Next, I would like to give the floor to our colleague, Ms. Ionela Cuciureanu, who Professor Ionuț Ciutacu very graciously agreed to let present before him. So Ionela, please, she will be giving us a presentation pertaining to latest rulings, international rulings, with the use of trademarks, a trademark that we all know and care for, I might add. So in the meantime, I can say that Ms. Cuciureanu is a lawyer and acting as an assistant in our faculty of law.
Because it's a subject that was very, very popular in 2019 when we had a decision in this respect that a bit was like, it came like a bolt from the blue. It was not at all expected. Because if are we to talk about known trademarks, about used trademarks, about popular trademarks, I think that McDonald's is one of a kind and is definitely a role model in this, on this subject. So it really came as a surprise when they had a trademark, Big Mac, that the cancellation division of the European Intellectual Property Office, and here it was a little mistake, a little misunderstanding in the title that was presented in the leaflet of the conference, because it's not a European Court of Justice ruling, it's a ruling of the European Intellectual Property Office. But yes, it came like a very big surprise when the cancellation division decided to state that Big Mac was not sufficiently used. It was a dispute between Super Mac and McDonald's, and in the end, the decision was that the trademark was not sufficiently used. So, let's get back in time a bit. The characters, the good, the bad, and the not so popular. I wouldn't say who's the good and who's the bad, because each one thinks the other is the bad. McDonald's doesn't need any presentation. The famous American multinational fast food chain dating back from 1940. Super Mac, they're Irish, is a chain of over 100 burger restaurants. So if you compare some 100 burger restaurants with the chain, it's like David and Goliath. They're located in Ireland, and the founder, Pat Donagh, chose the name from the Gaelic football team where he played as a high school student. He claimed that he suffered from trademark bullying by McDonald's, as McDonald's blocked from expanding into other areas of Europe, several areas of Europe. That's why somehow they remained confined to the borders of Ireland. But, and yes, they say that finally it was like an abuse from the part of McDonald's that claim, of course, the risk of confusion between the brands. And the not so popular, we know who is, the tricky burger, Big Mac. Big Mac, that's the registration. As you know, any trademark registration is registered in some classes of protection. They had Big Mac registered in class 29, 30, and 42 for several products. And I put this here, I won't read everything because we'll get hungry, but I put this here particularly because of the fact that we shall see in the end the decision from 2022, this decision from December last year, when finally they reverted a bit, granted the trademark finally. They say that McDonald's, yes, used the Big Mac, but not for all these products. So we shall see at the end of the presentation which are the products that remain from all this list. So this is the not so popular. The story. Old McDonald had a trademark, the Big Mac. In 1996, we have the registration at European Trademark Office. The Big Mac was registered then, so quite a history, we can say. Of course, renewed every 10 years since present. In 2017, Super Mac applied for cancellation of the Big Mac trademark for non-use in the European Union. As you know, the rules in terms of trademarks in the European Union, of course, it's not the US system where you've got to use your trademark. European Union, Romania also says, okay, you choose if you use or not your trademark, but if you don't use it, the risk is on you, because any interested party can come and claim the revocation of the trademark for non-use for a period of 5 years, so the last 5 years. And after 2 years, we have the UIPO decision that revokes the Big Mac trademark for non-use. That's the summary of the parties' argument. So the applicant argues that the UTME was not put to genuine use during a continuous period of 5 years following the date of registration in relation to any of the registered goods and services. Any is a bit too much, but the applicant. The applicant requests that the UTME be revoked in its entirety with an earlier date, namely 5 years from the date of registration. So that's what in the UIPA decision was summarized as the applicant's claim. And now we get to that question. Okay, so if finally the UIPA decided that the proof of use was not sufficient, what proof of use did McDonald's file? And the problem is that it's somehow surprising how like, a multinational of the stature of McDonald's choose to file so carelessly the proof of use, because if we analyze a bit what proof of use they filed, it was really carelessness. They had very few items they chose, and probably they relied more on their reputation. They felt like they're too big to let fail. We have 3 affidavits, just 3, signed by representatives of McDonald's companies in Germany, France, and United Kingdom, claiming significant sales figures in relation to Big Mac sandwiches for the period between 2011 and 2016. The cancellation division was not extremely happy with this proof. They claim that as far as the probative value of this kind of evidence is concerned, statements drawn up by the interested parties themselves or their employees are generally given less weight than independent evidence. We cannot blame them for this. It's rather evident. Second piece of evidence, brochures, printouts of advertising posters in German, French, and English showing Big Mac sandwiches and packaging for sandwiches, the boxes. And the materials appear to originate from the UTM proprietor and are dated also between the relevant period. This was okay. The brochures and posters show a sandwich on the menu along with other products or on its own. The prices are also provided on some of the material. The prices in order to show that it's not a piece of evidence that was fabricated afterwards, that it's real. Then, printouts. Printouts from the websites. And we have websites in almost every European Union state. We have McDonald's.be, Czech, etc., etc., etc. And of course, on not only the website, but the fact that the sandwich, the Big Mac, the contested product, let's say, the contested trademark, was depicted on the website. What did the cancellation division say? The mere presence of a trademark on a website is of itself insufficient to prove genuine use, unless the website also shows the place, time, and extent of use, or unless this information is otherwise provided. And they did not. They put there the excerpt from the sites, and that was all. Of course, the explanation does not do any good, because they say, in particular, the value of the internet extracts in terms of evidence can be strengthened by evidence that the specific website has been visited, and in particular, that orders for the relevant goods and services have been made through the website by a certain number of customers in the relevant period and in the relevant territory. We know that we don't buy our sandwiches on www.mcdonalds.ro or some other website, and they didn't submit any piece of evidence regarding the traffic, the number of visitors, the reach of the website. We don't doubt the website had this traffic, but they didn't submit anything. So the not so happy ending of the story is that after all this, the decision was predictable, and the cancellation division revoked the trademark for non-use because they considered the proof of use filed was not sufficient to prove a genuine use in the European Union. I was saying that this came really like a bolt from the blue because McDonald's certainly did not expect. Their lawyers certainly did not expect. It was treated internally as one of the various minor trademark litigations. Because we can imagine that McDonald's has very many trademark litigations, so it was like just one of those. Nobody ever imagined that they can have their trademark revoked for non-use. And having treated the issue so lightly, unfortunately, the result was this. Of course, they filed an appeal. And before the appeal, competition had a bit of fun. In Sweden, Burger King did not hesitate to use the decision as an advertising tool, so the not Big Macs, like a Big Mac, but actually big. The burger Big Mac wished it was, kind of like a Big Mac, but juicy and tastier, Big Mac-ish, but flame grilled, of course, anything but a Big Mac. It was, of course, now it comes to a discussion if from a competition, from an advertising point of view, this was okay or not, but they certainly made a point with their advertisement, and also this, also coming from Burger King. I say they filed an appeal, like, let's make Big Mac big again, and in December 2022, they succeeded. They made Big Mac big again, not for all the products in classes 29, 30, 42, but for the products that matter. In the appeal, it was, first of all, a procedural battle. It was easily to expect that they would learn from the mistakes and they would try to file supplementary proof of use, because it was clear, and they understood it, that the proof of use filed was not at all sufficient. So they supplemented the evidence with new pieces, presented on the phase of appeal for the first time. And here, of course, Supermax contested the admissibility of such proof. Fortunately for McDonald's, the Board of Appeals decision stated that, pursuant to the regulation regarding trademarks, the office may disregard facts or evidence which are not submitted in due times, but may accept facts or evidence submitted for the first time before it only were those facts or evidence are, on the face of it, likely to be relevant for the outcome of the case. And, of course, they have not been produced in due time for valid reasons. Here, with the valid reasons, debatable. In particularly where they are merely supplementing relevant facts and evidence, that was the argument they used, that they are merely supplementing the relevant facts and evidence, which had already been submitted in due time, or are filed to contest findings made or examined by the first instance of its own motion in the decision subject to appeal. They accept it, and when it comes to the evidence, they analyze the evidence filed. It was clearly more consistent, as you can see. We have consumer surveys by JFK from February, March 2019. This was a bit debatable because it was coming from the year of the decision. We have France, we have United Kingdom, giving information on the awareness or knowledge of the term Big Mac on an extremely high level, with McDonald's, associated, of course, with McDonald's fast food product, and among the general population at large, and among those who purchase or consume fast food products in Germany, the United Kingdom, and France. These were the three countries that Supermac contested. They limited a bit to these three. We have also several online newspaper and magazine articles regarding the Big Mac Index. We have photographs, this time not from the internet, but of original packaging from Germany in 2012 and 2014, from France in 2012 and until 2017, United Kingdom also, with dates that derived from the copyright notice on the back of the packaging. So this time they were a bit, they treated things with more care. Also, copies of receipts and or excerpts from electronic cash registers from the relevant period from restaurants, from McDonald's restaurants in the key countries, screenshots of television commercials broadcasted during the relevant period, this time accompanied with affidavits from employees of the advertising agencies that created the commercials. So if in the first instance we had 3 affidavits coming from the company, coming from McDonald's, this time we have some supplementary affidavits, but coming from the employees of the advertising agency. The Board of Appeals thoroughly analyzed all the evidence according to all the relevant criteria and for every class of protection. It's a decision that is like 60 pages, analyzes every class of protection, and in every class of protection, if these criteria are met. So territory, language, nature of use, extent of use, looking separately at each and every product. The decision, they lived happily ever after, because the decision states finally, after all this analysis, that it follows from the foregoing, after an overall assessment of the evidence, that it is sufficient to show the place, the time, nature, and extent of use, and thus genuine use of the contested UTM for the following goods and services. So that's what I was saying in the beginning, that the trademark was filed like for all the class heading, and now we have it a bit restricted. But if we look attentively, these are the products that are effectively used. We don't see McDonald's using it just for, I don't know, eggs, or we have in class 29 foods prepared from meat and poultry products, meat sandwiches, chicken sandwiches. Definitely, this was covered by the proof of use. Edible sandwiches, meat sandwiches, chicken sandwiches. Services rendered or associated with operating restaurants and other establishments or facilities engaged in providing food and drinks prepared for consumption and for drive. And it continues that the appeal is therefore partially well-founded as regards these goods and services, and the contested decision must be annulled to the extent that the contested UTM was revoked in relation to these goods and services. However, after an overall assessment of the evidence, it is not sufficient to show genuine use of the contested UTM as regards the remaining goods and services, and the appeal is therefore not well-founded with respect to these goods and services. But we can say that it is definitely better than nothing. It is definitely better than not having your trademark at all. They have it for sandwiches, the key product, their key product. So Big Mac is happy again. And thank you for your attention. Of course, if you have any questions, please. Thank you.
Okay, thank you, Jonella, for your very vigorous presentation and very nice presentation. I think I was surprised to learn about the Big Mac losing their trademark, especially for a product that is so well known and so well founded. I think that everyone who's been to McDonald's has actually heard of a Big Mac.
Believe me that they were surprised too.
So, yeah, especially. Do we have any questions?
Just a question concerning...
Professor, can you please turn on the microphone?
Yes, yeah, just a question concerning the class 30, because it concerns edible sandwiches. So because there are non-edible sandwiches.
I've never understood that. Me neither. It's like it was registered like that, and at that time when they filed it, the class heading was like that: edible sandwiches. Because they have many things. If you look at the heading in NISA classes, you shall see edible ice, edible chocolate, edible, a lot of edible things. It's the UEPO.
In my opinion, McDonald's products are not edible at all. It's a personal opinion.
Maybe for this, maybe because of this.
Merci. So thank you very much. Do we have other questions? No? Okay, from our online participants, maybe? Very well. So, thank you very much, Jonella.
Thank you.
And right now, I would like to invite Ms. Daniela Hudelcu.
to give us her presentation. She is with us online. And I think that I can share your presentation. Would you like me to share it, or would you rather share it yourself? Professor? Just 1 second, I cannot hear you. Just 1 second, I don't think we can hear you very well, or I cannot hear you in the room, the hallway.
Mă auziți? Mă auziți, da?
Da, mult mai bine.
Pot să încep, da?
Da, tot în regulă, vă rog.
Se aude. Am făcut și share screen, să vede.
Nu, îl puteți reface, vă rog, cred că s-a închis la un moment dat.
Da, s-a închis.
Acum îl vedem.
Ne vedem și ne auzim, da?
Ne vedem și ne auzim, totul bine.
Da. Daniela Cudoicu, doctorant la Universitatea București, școala doctorală a Facultății de Drept, pe specialitatea drept fiscal, financiar și fiscal. Am ales o temă pentru această conferință care să aibă legătură și cu dreptul european al afacerilor, respectiv cu marele domeniu al jocurilor de noroc. După cum știm, este o activitate care se desfășoară pe întreg spațiul mapamondului, dar în ceea ce privește pe spațiul european, reglementările sunt foarte clare. În ceea ce privește România, în acest domeniu al jocurilor de noroc, România s-a aliniat potrivit tuturor reglementărilor prevăzute în directivele europene, precum și potrivit jurisprudențelor instanțelor europene. După cum știm, directivele cele mai importante cu aplicabilitate asupra domeniului jocurilor de noroc sunt cele pe care le voi prezenta în continuare, dar înainte de aceasta trebuie să avem cunoștință de tipurile de jocuri de noroc asupra cărora se percep taxe, iar aceste taxe în legislația română se clasifică în taxe datorate pe licența de organizare de jocuri de noroc, pe taxe aferente autorizațiilor de exploatare a jocurilor de noroc, precum și pe taxele speciale. Ceea ce necesită o maximă atenție din punct de vedere fiscal, mă refer aici la taxele speciale, care, pe lângă cele de licențiere și de autorizație, taxele speciale sunt taxe cu caracter, și spune numele, cu caracter special, care pe parcursul timpului, cel puțin din 2014 până în prezent, s-au cumulat. s-au acumulat în sarcina acestor organizatori de jocuri de noroc. Bun. În articolul pe care îl voi publica și la care m-am pregătit, sigur vom face o prezentare a naturii juridice a tuturor taxelor datorate de aceste societăți, până la urmă societăți care desfășoară o activitate economică pe teritoriul țării, cât și pentru societățile care desfășoară activitatea în mediul online. Diferențe există în ceea ce privește și cuantumul și taxelor datorate. Diferențe sunt și cu privire la modul de organizare, modul de percepere și de reținere a impozitelor obținute din veniturile atât a organizatorilor cât și a jucătorilor din activitatea însăși de jocuri de noroc. Taxele administrative în principiu sunt taxe care ajută, de fapt, toate aceste taxe se colectează la bugetul de stat și ajută în definitiv la o mai bună organizare atât a Oficiului Național pentru Jocuri de Noroc ca instituție care deține monopolul pe această activitate în România, cât și pe o mai bună administrare a activității însăși. Și voi reveni asupra acestui aspect. Cu privire la taxa de promovare a jocurilor de noroc, ultimul act normativ care reglementează această activitate, sigur, este întemeiată și a suscitat multe controverse în domeniu, fiind un domeniu care, deci vorbim de publicitate, vorbim de promovarea însăși și alte activități cu același specific sau care rezultă și conduc însăși la ideea de publicitate a jocurilor de noroc. Aspectele sunt foarte diferite de la o țară la alta. România, în opinia mea, în comparație cu mai multe țări europene, a devenit mai maleabilă, mai înțelegătoare cu organizatorii de jocuri de noroc. Sigur, respectând și având în vedere în permanență directiva europeană care reglementează, de fapt, publicitatea și comerțul electronic, ceea ce voi explica și voi aduce în prim plan necesitatea și voința legiuitorului în momentul în care a stabilit o asemenea taxă de promovare a jocurilor de noroc. Cu privire la neplata taxelor, legislația atât europeană și o vom vedea și în jurisprudența Curții de Justiție a Uniunii Europene, sancționează drastic neplata acestor taxe. Sigur, după cum putem observa, sancțiunile privesc sancțiuni administrative, contravenționale și sancțiuni penale. Nu vă voi reține atenția acum asupra detalierii asupra acestor sancțiuni, Voi merge mai departe, în sensul în care reglementările europene care reglementează și aduc cumva în atenție întreaga activitate și a acestui domeniu sunt cele expuse pe slide. Ceea ce, în opinia mea, a suscitat multe controverse în perioada anilor 2000-2010. Este vorba de directiva 2006/112 privind sistemul comun al taxei pe valoare adăugată, care, din punct de vedere al mai multor țări, spre exemplu Spania, Italia, Marea Britanie, la acea vreme Irlanda de Nord, au considerat ca fiind activitatea însăși de jocuri de noroc să fie exceptată de la sistemul comun al taxei pe valoare adăugată. Ori a venit Curtea de Justiție a Uniunii Europene și a menționat în concret faptul că aceste societăți nu pot fi exceptate de la aplicarea acestei directive. Cu privire la Directiva 31 pe 2000, cum spuneam pe scurt, Directiva Comerțului Electronic, jocurile de noroc și întreaga activitate trebuie supusă și acestei directive. Restricțiile care pot să conducă la o eventuală exceptare a măsurilor cuprinse în directive, acestea pot fi stabilite sau pot să fie cumva acceptate numai pe baza jurisprudenței Curții de Justiție a Uniunii Europene. În considerarea faptului și respectiv a prevederilor articolelor 51 și 52 din Tratatul de Funcționare a Uniunii Europene. Restricțiile trebuie aplicate fără discriminare și aici am în vedere mai multe decizii ale Curții când în repetate rânduri, cu alte prilejuri și cu o altă tematică de soluționare a cauzelor, dar având în vedere domeniul jocurilor de noroc, aceștia chiar au specificat și au precizat că restricțiile trebuie aplicate fără discriminare și trebuie să fie proporționate, respectiv să fie adecvate pentru realizarea obiectivului urmărit și să nu depășească ceea ce este necesar pentru atingerea acestuia. Am chiar citatul. În acest sens, măsurile pe care România, prin actele normative adoptate, în opinia mea, consider că sunt măsuri adecvate, sunt măsuri care contribuie la o mai bună funcționare a acestor societăți pe teritoriul țării și, respectiv, dacă ne referim la mediul online, și pentru acele societăți care desfășoară jocuri de noroc în mediul online. Din punct de vedere al publicității, pentru că insist un pic asupra acestui aspect, în opinia mea, atât în România cât și în țările europene, consider că această activitate a acestor organizatori de jocuri de noroc trebuie să respecte anumite reguli. Cum spuneam, bazată pe directivă. Și atunci, activitatea de publicitate să fie identificată ca fiind într-adevăr o publicitate la jocuri sau la un anumit tip de jocuri de noroc, compania care furnizează publicitatea și care susține să se desfășoare jocul, să fie clar identificată potrivit tuturor mecanismelor de identificare a unei persoane juridice. Apoi, la fel, identificarea ofertelor, jocurilor și concursurilor, pentru că știm din diferite activități, și vă dau un exemplu aici, activitățile sportive, se utilizează în mod frecvent publicitatea la jocuri de noroc, la diferite tipuri de jocuri sau în mod cu caracter general jocuri de noroc. Condițiile să fie accesibile și prezentate în termeni clari și simpli cu privire la acest aspect. În ceea ce privește serviciile în cadrul pieței interne, potrivit directivei 123 pe 2006, până în 2013, România a avut anumite probleme din acest punct de vedere, până odată cu publicarea ordonanței 42 pe 2015, când s-a reglementat accesul și a persoanelor juridice care desfășoară activitate de jocuri în spațiul european, respectiv spațiul economic european. Astfel că în prezent putem spune că aceste servicii de furnizare de jocuri de noroc sunt bine reglementate în spațiul european, neexistând nicio interdicție cu privire la acest aspect. Sigur, există mai multe decizii ale Curții de Justiție a Uniunii Europene care au contribuit la adoptarea și la reglementarea, în opinia mea, puțin cam târzie a serviciilor europene, dar acum, în 2023, putem spune că lucrurile, și de mai mulți ani, lucrurile merg pe un făgaș mai bun, așa. Mai departe, în ceea ce privește practica judiciară relevantă, de care înțeleg să fac o expunere mai detaliată, voi face referire la practica națională și practica europeană. Dacă la nivelul practicii judiciare naționale, în opinia mea, nu consider să vă rețin atenția acum cu privire la acest aspect, dar la practica judiciară europeană, potrivit cauzelor pe care le-am expus, aceste cauze soluționate la nivelul Curții de Justiție sunt cauze cu impact semnificativ asupra legislației române. În ceea ce privește doar câteva cuvinte cu privire la fiecare cauză, cauza 440 pe 2012 privește fiscalitatea și TVA-ul pentru jocurile de noroc, respectiv TVA-ul din punct de vedere al reglementării unui stat membru care supune exploatarea aparatelor de tip slot machine cu posibilități limitate de câștig în mod cumulativ a TVA-ului și a unei taxe speciale. Baza de impozitare a câștigurilor din obținute din aparatele de slot machine. Este o cauză care reclamantul a fost, mă rog, din Germania și această cauză a avut un impact semnificativ, astfel că după 2012, Germania și-a modificat în mod corespunzător legislația, astfel că baza de impozitare a TVA-ului pe activitățile de exemplu, de vânzare-cumpărare de aparate de slot machine, să fie bine și clar determinate în legislația internă. Cu privire la cauza Gambelli. Cauza Gambelli e o cauză interesantă din punctul meu de vedere, pentru că este utilizată aproape în toate cauzele cu specific de jocuri de noroc. Sigur, este o cauză printre primele cauze cu acest specific, după care Curtea de Justiție a început să soluționeze și pe această tematică. Apoi, cauza Platanica. Această cauză la fel, are același regim în sensul că nu lasă loc să se interpreteze de către nicio țară membră a inexistenței unei competiții între organizatorii de jocuri de noroc care desfășoară la nivel teritorial, național, în raport cu organizatorii de jocuri de noroc la nivel european. Și existând diferențe până la acel moment din acest punct de vedere, eu apreciez și de aceea am adus în atenție că a existat o necesitate imperioasă pentru existența unei jurisprudențe în acest sens. Ea este și utilizată deseori atunci când, din partea unor țări care nu sunt sau doresc să se prevaleze de această cauză, îi dau o altă conotație și o altă interpretare. În ceea ce privește cauza Lindman, această cauză este o cauză din Finlanda, reclamantul este din Finlanda și curtea a reținut că acele câștiguri provenite din jocuri de noroc neautorizate în Finlanda erau considerate venituri impozabile, în timp ce câștigurile provenite din jocurile de noroc organizate în acest stat membru nu constituiau venituri impozabile. Deci, existența unor asemenea inadvertențe nu era posibilă și nu trebuia să se întâmple în spațiul european. Și ultima cauză, cauza 153 pe 2008, vorbim de, la vremea aceea, Comisia Comunităților Europene împotriva Regatului Spaniei, privește neîndeplinirea obligațiilor de către un stat membru cu privire la libera prestare a serviciilor, respectiv a articolului 49 și articolul 36 din acordul privind spațiul economic european, cu accentul pe fiscalitatea directă, respectiv a impozitului pe venit și a impozitelor percepute pe sumele câștigate la loterii, jocuri și jocuri de pariuri, mă rog. Curtea în această cauză a reținut că legislația fiscală care prevede impozitarea câștigurilor obținute din participarea la toate tipurile de loterii, jocuri și pariuri organizate în afara Regatului Spaniei, în timp ce câștigurile provenite din anumite tipuri de loterii, jocuri și pariuri în acest stat membru sunt scutite de impozitul pe venit. Deci, cu alte cuvinte, pentru uniformizarea impozitelor și respectiv a tuturor obligațiilor fiscale datorate de organizatorii de jocuri de noroc ar trebui să fie reglementate, având, cel puțin de Curtea de Justiție a Uniunii Europene, având de vedere faptul că nu există o directivă la nivel primar pentru reglementarea acestui domeniu. După cum am arătat, directivele colaterale care privesc activitatea economică în general sunt aplicabile și organizatorilor, respectiv societăților care desfășoară activități de jocuri de noroc. În mare, cam acestea au fost aspectele. Ceea ce vreau să, într-un minut, i-aș dori să aduc în discuție, mi-a plăcut foarte mult un aspect, nu știu dacă toată lumea știe, Dostoevski a fost un jucător împătimit al jocurilor de noroc și în romanul său, pe care l-a scris doar în 26 de zile, nefiind un roman așa de stufos, precum celelalte romane, nota în romanul său cu titlul Jucătorul nota așa: în lumea jocului se știe foarte bine că un jucător, când e atras cu pasiune într-o luptă unică împotriva hazardului, poate rămâne așezat la masă timp de 24 de ore fără a-și lua ochii de la cărți sau de la ruleta care se învârtește. Și adaugă mai departe: într-o clipă mi-am dat seama că deja nu mă mai interesau banii, ci senzația de risc, impresia de aventură, ceea ce însemna să merg împotriva oricărei logici. De atunci am reflectat mult asupra acestui lucru și am ajuns la concluzia că este foarte posibil ca, trecând prin atâtea senzații, departe de a se sătura de ele, spiritul devine și mai dornic și cere senzații de fiecare dată mai puternice, ajungând până la inerția definitivă. Deci, cum spuneam, în principiu și domeniul jocurilor de noroc, ca parte integrantă dintr-o activitate economică a țării noastre și a tuturor țărilor din spațiul economic european, fiind o activitate care aduce și contribuie la bugetul de stat, eu vă mulțumesc foarte mult și mă scuzați pentru eventualele inadvertențe de la început. Mulțumesc!
Nicio problemă, mulțumim mult, doamna Hudelcu. Avem întrebări din sală sau dintre participanții online? Do we have any questions for Ms. Hudelcu? Okay, I see no raised hands.
Sorry, I wanted just to...
Yes, please.
A few remarks. Well, of course, I couldn't understand what I said, but as I know the topic, I could guess a part of the presentation. Just three remarks, personal remarks. The first one is that France was very involved in all these cases pending before the Court of Justice at this time, Gambelli and, for example, Gambelli e Placanica, many Italians reference cases concerning the monopoly in this field. And I remember, so we submitted written and oral observations in many cases in this field, and I remember that the position of the Commission was very, very harsh. I remember. Second remark is that finally the French Conseil d'État decided a few years ago to refer a case, the Turf case, concerning the monopoly, and the answer of the court was not so clear. But finally, you know, it was the French government which decided to open part of the market, especially a great part of the market on internet, because I don't know how to say in Romanian or in English, but on the non-internet gambling market, it's a monopoly. It's still a monopoly in France. And the third remark is concerned the taxation, not the taxation of the organizers, but the taxation of people, you know.
Of the benefits obtained?
Of the benefit. Because, and I just wanted to give you the example of poker. Because in France, for a long time, the poker was considered as a game of chance. And the consequence was that the winnings, the gambling winnings of poker were not subject to income tax. But finally, about, I would say, 10 years ago, the finance ministry changed its mind and decided that from now on, the poker would not be considered as a game of chance. And the consequence was that the gains were due to be subject to subject of income tax. And the problem was that it was not just from now on, but the finance ministry has a possibility to impose for the 3 years before. And so there were many actions before the French administrative courts. And the problem also was that not only the finance minister decided, of course, to ask to impose the gains from the 3 years before, but also to impose fines, because you forget to to declare your gains. So, and there were actions before the administrative court, and finally the French Conseil d'État, probably 7 years ago, ruled that it was not possible to impose fines because it was a change of doctrine from the Ministry of Finance. So it was not possible for the Ministry of Finance to impose fines because it was not, the fault of the gamblers, of the gamers or gamblers.
Gamblers,
of the gamblers not to have declared because, at this time, 3 years before, they were not aware of the obligation to declare the gains, the poker gains. And so, of course, they had to pay the income tax, but not the fines. And the fines could be very high, between 40 and 80% of the gains. So they won partially their because, of course, the action was more general. But finally, they didn't have to pay the fines for the years before.
Can I just ask as a curiosity, was the fine imposed for non-declaring?
Yes.
Or was it imposed for, the non-declaring of a gain that was not mandatory to be declared, or that could have been declared or should have been declared but was not? So I'm asking about the state of legislation before before the changement made by the Ministry of Finance?
Well, it was not a change of legislation, but, you know, a change of doctrine, because, you know, of course, just, you don't have, you know, a decree or a law providing that poker game, you know, it was just a doctrine of the finance administration. But so it was very unfair from the tax administration, because the tax administration changed its mind and decided that from now on, and for the 3 years before, they had to pay, you know, income tax on the gains of poker. But they say you should have declared your gains at a time when it was not, you know, compulsory. It was not. It was considered as a game of chance. So yes, you should have declared your gains. So you didn't, because you followed the former doctrine of the administration, and that's why you will be imposed fines. It was completely unfair, and it was, you know, it was not very, so difficult for the French Conseil d'État to decide that there will be no fine, because you cannot reproach, you know, a gamer not to have declared the gains before the changing of mind of the French tax administration, you know.
Yes.
So, thank you.
Thank you, Professor. Ms. Houdelkout, do you want to add something?
No.
Very much for your presentation. Next off, we have Mr. Alexandru Bajdeki, who is a lawyer and will be joining us today via Zoom.
Hello, do you hear me?
Now I think so, if you speak a little bit louder.
Okay, do you hear me now?
Perfect, thank you. I will share the presentation momentarily.
Okay, thank you. Before I start, I want to greet all the participants to this conference. Unfortunately, I'm on the move right now, so I cannot join by the video. I hope that the internet will work well, and I'll try to be short but with substance, because I'll prepare some article for this matter. First of all, I've chosen this subject because it's both related to European business law and my PhD research, which is the right to a decent standard of living. So this is the theme of the presentation that I am presenting today. So can we move on with the first slide, please? Okay, thank you. Okay, so we have a new directive, which is 2041, which entered in force in 2022. And we have a deadline for implementation this directive, which is November 5th, 2024.
I have
However,
a request.
Romania,
Sorry,
which
Mr.
has a national plan for reform and recovery and resilience. Romania has to implement.
Mr. Bajdeki, sorry, can you speak a little bit louder, please?
Okay, sure, I will.
Thank you.
Romania has to implement a mechanism to implement this directive sooner than the official deadline, which is the first quarter of 2024. So it's a supplementary obligation which comes from the National Plan for Recovery and Resilience. As you can see, the minimum wages dispute on how much the minimum wage should be in Romania. We also have a present legislation
Little bit of technical difficulties.
Of goods of services, which of 174 from 2020, but is not applicable in this. Do you hear me now? The law is not applicable in this moment because the National Statistics Institute is saying that it doesn't have the quantities for the goods and services in order to calculate the basket of goods and services. And as we move to the next slide, I want to emphasize that the aim of this directive is achieving of decent standard of living, which is also a constitutional right in Romania, reducing in-work poverty as well, promoting social cohesion and upward social convergence and reducing the gender pay. This is also mentioned in the preamble of the directive, which mentions the Article 31 of the Charter of Fundamental Rights of the European Union, which mentions that, which provides that the right of every worker to working conditions which respects his or her health, safety and dignity. The European Social Charter established that all workers have the right to just condition of work. So it recognized the right of all workers to a fair remuneration sufficient for a decent standard of living for themselves and their families. This mentions that this can be achieved by collective agreements, as also mentioned as collective bargainings, as a way to achieve collective agreements, as well as statutory minimum wage setting mechanism to ensure the effective exercise of this right. So the directive fixes, let's say, introduces 4 examples of elements to be considered in the on assessing and setting a minimum wage. The first of the elements is the purchasing power of statutory minimum wage is taking into account the cost of living, which also can be equivalent to a basket of goods and services. The second element is the general level of wages and their distribution. The third, the growth rate of wages. And the fourth being the long-term national productivity levels and developments. On the next slide, I will please ask you to change that to the next slide. We have the methods of achieving minimum wage, which the first, the directive mentions is collective bargaining. So after the collective bargaining, we should achieve collective agreements, which Romania is not, let's say, the best at this method because we don't have the collective bargaining in Romania is not quite popular because of different reasons. Also, we have the statutory minimum wage, which mentions 2 indicators to be used as examples, and the public opinion has referred to these indicators as mandatory, but they are not. They may be used as 60% of the gross median wage and 50% of the gross average wage. They can be used, but they are not mandatory, as I said. If there is a formula, then every 2 years, and if there is an automatic indexation mechanism at least 4 years, the minimum wage should be revised. Okay, for the next slide, I will have the challenges for the minimum wage in Romania. The first of all is that taxation is more business friendly than wage friendly, and at this moment there is not a political will to change that. Romania development models promotes at this moment, or let's say in the past, more low wage jobs than high value, high wage jobs. This may change in the following years because we have problems with people leaving Romania. So probably the authorities will change the economic development model. There are little to non-trade unions in the private sectors, and employers' organizations are not consolidated. As you may know, the trade unions are more active in the public sector, and the employers' organizations are now in the process of being consolidated because there are only 3 employers organizations which are representative at the national level right now. It used to be 5, for example, in the past. The minimum wage is also a very political issue because setting the exact amount is always a political debate. And different political actors want to have a higher minimum wage, others want a lower minimum wage because it's related to their political vision. As mentioned before, there is not, right now, there is not an assessment of the basket for goods and services required for a decent living, and I can see that there is not a political will to change that. So the problem is, if we don't have a basket of goods and services for setting the decent, the right to decent living, I'm sure the matter of assessing and establishing the national minimum wage will always be political driven. So there is also no collective bargaining culture in Romania. For example, there are other countries in Europe that collective bargaining is the main or the only way to establish the minimum wage. There is not there isn't a statutory minimum wage. Okay, for the next slide, I'm making some predictions for the future. I think that the minimum wage, even though we have a directive in Romania and national recovery plan requirement for setting objective criteria, will remain arbitrary because the political and social actors always will try to argue for or against the example indicators mentioned in the directive. So I don't think that will be directly applicable. For example, I don't think we will have the law which will say that the minimum wage is a % of something. So it will always be a political decision. Also, we will not have assessed a basket of goods and services for decent living. And for the last slide, I've mentioned some opportunities which I perceived. First of all, is the strengthening of the collective bargains in some economic sectors, because we have a new law on social dialogue and a new government decision on economic sectors, which are the base for collective bargainings and collective agreements. So probably we will have more collective bargainings in some economic sectors, because in those sectors we probably have trade unions and employers organizations. There is also a horizontal measure mentioned in the directive that in the awarding procedure of public procurements or concessions contracts, the organizations who apply in these procedures will have to comply with the wages, the minimum wages, and this will be also a way to enforce the new legislation of the minimum wage. And the last opportunity, which is more constitutional right opportunity, constitutional law opportunity, is that when we will have a formula for the national statutory minimum wage, the formula would be challenged to the Constitutional Court to see if it guarantees a decent standard of living. So probably we will have in the future some Constitutional Court decisions in this matter and more than simply arbitrary decisions. So this is my presentations. I hope the information were useful to you, and I thank you for listening to me.
Sorry, thank you very much for this very interesting presentation. if we have no questions, so I can start by asking my own question, I think. Regarding what you mentioned, the minimum basket and the idea of the equitable and ethic minimum wage. I know that the political wheel has no input in it, but however, the media and the press regularly does press shows and TV shows pertaining to this. So I was wondering if if you have knowledge, if you have any knowledge pertaining to the associations, the trade unions that keep in mind this, the state trade unions that keep in mind this and that use this as leverage in order to negotiate with the state authorities.
Yes, I'm aware. I think always the trade unions will push forward the idea that the minimum wage should be based on the minimum, the decent standard of life. However, how we define minimum standard of decent standard of life, it's hard to define, let's say, because we go back to the political decision. For example, the actual law on the basket of goods and services, there are some examples of goods and services, but we might always ask the question, why these services and goods and why not others? So we go always back to the political decisions. Of course, the private organizations, which includes trade unions and researchers, will propose solutions, but in the end, they're just proposed solutions and not law. As I said before, the law is not applied right now because there is not a political will to define how much of certain goods should be included in the basket of goods and services. So always will be a political decision. That's my opinion.
Perfect.
And I think this is also the opinion of a recent economic council and social and economic council study, which says that there is not possible to fix a formula for minimum wage. Thank you.
Thank you as well. I think you have a second question.
Thank you. Yes, you know, since I'm a member of the French Conseil d'État, I don't follow so thoroughly than before the EU legislation. And I'm very surprised by the existence of this directive you talked about, the very recent directive, because it was admitted at least before, that the union has no competence at all on wages. And you remember that, you know, Article 153 of the TFEU, I think it's a legal base of the directive, but you will tell me, you will tell us, you know, provide that the union shall support, complement the activities of the member states in many, many social fields, but except, you know, paragraph 5 of the article provides, specify that this article shall not apply to pay. So I would be very interested, you know, to know, you know, how the Commission and the Council explain, you know, the competence for the Union to adopt such a directive dealing with minimum wages, and so I will be very interested by that, because, you know, before it was impossible to imagine a directive of the union dealing with the wages, minimum wages, and so on. So thanks in advance for your answer.
Thank you for your question. It's very interesting indeed. I've also looked in the preamble of the directive, and I see that it's based on many articles. For example, the Article 3 on the Treaty of European Union, which mentions the aim of the Union to promote the well-being of its people and to work to the sustainable development of Europe. This is a first example. The second one is the Article 151 of the Treaty of the Functioning of the European Union, which provides that the Union and the member states having in mind fundamental and social rights such as those set in the European Social Charter. So this is a second ground, and more, it goes to Article 31 of the Charter of Fundamental Rights of the European Union, which provides the right for every worker to working conditions. And of course, it mentions the European Social Charter. But to be honest, I think that this directive is more like wishful thinking. So we should have better minimum wages. We should have transparent minimum wages.
Thank you. I'm not very convinced. I'm not very convinced because, you know, the Charter doesn't extend the competence of the Union. And the problem is... Oh, sorry. Oh, sorry.
So always on the member states. So it's not imposing on the member states.
Thank you for your answer, but you know, I'm not very convinced because, you know, as you know, the Charter doesn't extend the competence of the Union, and it's quite difficult because you have the legal base. What is important is not the objective of the treaty, it's very important, but the more important is the legal base, and the legal base is Article 153, and in this article, paragraph 5, provides that the intervention, you know, of the Union in the social field cannot apply, doesn't apply, sorry, to pay. So it's quite surprising, but of course it's not the first time, you know, in the story of the European Union and the European community before that the Union extends its power beyond what is provided by the treaty. But it's interesting because, you know, for a long time, probably France was very in favor of this kind of interventions, but some member states like Germany or, of course, UK, and were very opposed, and probably the Brexit, you know, facilitated the adoption of the directive because probably UK was the more opposed member state on this topic. And so, but it's very interesting, very interesting. You know, I was not aware of that, and I thank you a lot for your presentation. Very interesting. Thank you.
Thank you as well. I think that next off we can have Professor Ionuț Ciutacu, who is joining us online. He graciously gave his part beforehand, and he will be presenting the article, The Role of Literis Contract in the Development of Romanian Business Law. Professor?
Good afternoon. First, I salute all the participants to the conference. I will present you a few ideas regarding the Literis contract and the role that this contract had in the development of the Roman business law. As an introduction, the Literis contract appeared in an era in which we see the transition from the excessive formalism specific to the old ius civile to the specific consensualism to classical Roman law. In the ancient era of Roman law, legal acts were concluded only with the observance of strict formal conditions, to the detriment of real will of the parties. Along with the evolution of legal ideas, the Roman understood the role that the agreement of will of the parties has in the formation of the legal act, and managed to distinguish between the act generating legal effects, negotiorum gestio, and the act ascertaining the manifestation of will, instrumentum probationis. This was captured following a long evolution, starting at the time of consecration of Literis contract and ended at the time of emergence of literal obligations. The results of this evolutionary process inspired Roman jurists to create legal instruments suitable for Roman business law and to provide the models for any society based on private property, but especially on the exchange economy. For a long time, Romans concluded contracts in verbal forms, but this form of contracts no longer corresponded to the realities of the end of the Republic, when the Roman economy transformed from a natural, closed economy into a genuine exchange economy. Society developed and commercial transition took off. Commercial operations were often concluded between Roman citizens and pilgrims and required some huge sums of money, which are often borrowed from bankers. In order to borrow money, they use a legal act of ius gentium named stipulatio. This was a unilateral contract concluded by question and answer, which presented a great disadvantage. The solemn form required for its conclusion did not require the presence of witnesses, who, if necessary, to prove the content of the stipulation. In order to remove this inconvenience, the parties were put in the situation to request the presence of witness at the time of concluding the stipulation. But even this was not enough, because it could happen that, exceptionally, the witnesses did not want or were not able to testify. This fact was likely to put the creditor in the situation of not being able to demonstrate the existence of his right of debt. In order to avoid such consequences, it was necessary to conclude the document. But what form should that document take? Roman jurists solved this problem by taking inspiration from the way of life of the paterfamilias. They noticed that the head of the Roman families of the Roman civil family had the habit to keep several registers in which he recorded certain events. The most important of these registers was the Codex Accepti et Expensi, that translates as the register of amounts received and amounts paid. This codex was a house register that contained two columns. It was a formal contract of strict and unilateral law. Its object was amount of money and could only be concluded by Roman citizens because it was specific to ius civile. The literary contract had the advantage of being concluded between absentees, and that is why the parties use it instead of verbis contracts, the conclusion of which always required the presence of the parties. This register was organized in two columns, accepta et expensa. In the first column, the paterfamilias mentioned the amounts received, and in the second, he recorded the amounts paid. These registers began to be used by bankers to record the operations they carried out. Sometimes, the banker used the cash register to keep track of amounts of money and that he had paid or received based on contracts that had been concluded before being entered in the register. The respective notes do not coincide with the substantive or formal conditions that had to be met for the birth of certain contracts, but are simple findings of the execution of certain obligations. For example, Primus had to receive from Secundus 100 aces for the sale of a slave. After collecting the amount of money from the debtor, the creditor entered the amount of 100 aces in the collection column. This operation is called acceptilatio, which had its origin in the Latin acceptum fere. If, however, Primus had to return to Secundus 50 aces that he had borrowed from him, he had to enter this amount under the heading expensa. This operation was called expensilatio, which has its origin in Latin expensum fere. Therefore, not all the mentions made by the banker in one of the two columns were generating obligations. Mentions that did not produce legal consequences were designated by expression nomina arcaria, which translates as house registration. This name has its origin in the term arc, which is used with the meaning of money box or treasure. Instead, Other mentions were made with the aim of generating obligations. This time, the mentions made were no longer simple notes without legal value, but represented the basic conditions necessary for the birth of the literary contract. They were designated by the Roman legal text by the term nomina transcriptitia. The jurisconsult Gaius tells us that an obligation is contracted for a document such as when transcribing claims, and the transcription of receivables is done in two ways, either by transferring a benefit to one person account or by transferring an account from one person to another. Codex Accepti et Expensi produced legal effects in two situations. These were mentioned by the jurisconsult Gaius, the change of the debtor, transcriptio a persona in personam, and the change of the legal basis of an obligation, transcriptio a re in personam. Transcriptio a re in personam, a persona in personam, consists in replacing one debtor with another. This operation was carried out by making two entries in the banker's register and represented a novation by changing the debtor. Novation with change of debtor was done according to a prior agreement, following which one debtor, Titius, was replaced by another. This was done when the debtor authorized his banker to make a payment on his behalf. This legal operation was carried out in two stages. First, the creditor wrote in the receipt columns, called accepta, that he had received the amount of money from the debtor. Although, in reality, he had not received anything. And he mentioned in the payment column that Mevius, Titius' banker, had received the amount of money from the creditor, an amount that he confirms. Transcriptio a re in personam is realized by means of two entries that the banker operates in his register. The respective recordings were made as a result of a prior agreement. Their role was to create a more favorable situation for the creditor, which would allow him to execute an obligations under the conditions he desired. But not all contracts established by the rules of Roman law allowed the creditor to be in a superior position to the debtor. This is what happened with the contracts of good faith, which appeared towards the end of the Republic, against the background of the evolution of legal ideas and the affirmation of the principle of the real will of the parties. This legal principle governs the formation of the legal will, which includes two elements, one internal or psychological, and one external or social. In order for the agreement of will of the parties to be validly expressed, there had to be agreement between the internal will and the externalized will. Then there was no agreement between two elements and a trial was initiated. The judge had to make an ex fide bona interpretation, by which he tried to establish the intention of the parties who had concluded the contract. Therefore, the judge had to determine whatever the will of a party had been vitiated, in the sense that the said party had been forced to conclude the contract under conditions in which normally he would not have done this. The obligation arising from good faith contracts were not to the advantage of the creditor, because they did not allow him to be in a privileged position in relation to the debtor. Good faith contracts did not allow creditors, who were a part of the privileged social category, to use this status to force debtors to enter into disadvantageous contracts. The bankers were interested in concluding solemn contracts, because these contracts were not governed by the principle of the real will of the parties. They were concluded subject to the fulfillment of the formalities required by law and were sanctioned by strict legal actions. These actions did not give the judges freedom of appreciation. They instructed them to interpret the contract ad literam and to observe only if the parties had complied with the conditions required by the law for the conclusion of this contract. Could the obligation arising from good faith contracts be transformed into literary obligations? Yes, through the transcriptio array in persona. What operations did the banker have to perform? What was mentioned in the receipts column, accepta, and what was mentioned in the payment column, expensa. If the debtor owed 100 aces according to a sale purchase contract, the creditor mentioned in the receipts column, accepta, the fact that he had received from him 100 aces, although in reality he had not received them. In this way, the obligations borne from the sale purchase contract was extinguished. Later, the creditor mentioned in the column of payments that the fact that he had given the debtor 100 aces, although in reality he had not. Nomina transcriptitia continued to be applied among Roman citizens in the classical era as well. But this type of contract did not apply to relations with pilgrims. In order to offer solution to the pilgrims, who had become the main commercial partners of the Romans, literary contracts were created adapted to their needs, which fell within the scope of ius gentium. The jurisconsul Gaius called them chirographa and syngrapha, and says that they are used when someone gives in writing that he owes or that he will give. Chirographa were unilateral contracts concluded in written form, drawn up by the debtor and signed by him. They have their origin in Greek law and offer the interested party the opportunity to obtain a receipt that proves the payment and the cause of the contract. Syngrapha is another written contract that originates in Greek law. It was written and signed by the creditor and the debtor. Often, the syngrapha also bore the signatures of the witnesses who had participated in its conclusion. Compared to the advantages it presented, this contract began to be used since the time of Cicero. Syngrapha and chirographa disappeared after Emperor Caracalla issued the famous imperial constitution of 2012, through which he generalized Roman citizenship. The Institute of Emperor Justinian show us that in the post-classical era, bankers no longer used Codex Accepti et Expensi. This had long fallen out of use, as other legal instruments had meanwhile emerged that better served the bankers' interests. In order to avoid the consequences of the economic crisis that society was going through, the bankers took advantage of the debtor's precarious economic position and sought to establish the safest evidence, making the debtor sign written documents for the debts contracted through stipulation or by mutuum agreement, without the later receiving of the borrowed money. To stop this practice, Emperor Justinian improved the procedure created by Caracalla, setting a 2-year deadline for the initiation of the judicial procedure. If this procedure was not initiated within the term stipulated by the law, the debtor could no longer contest the document and remain bound on the basis of the receipt he had signed. This document, concluded in post-classical era, should not be confused with the literary contract, although the temptation is great. Although the physiognomy of the literal obligation in the post-classical era was inspired by the literary contract and similar contracts signed between Roman citizens and pilgrims, it is a distinct legal figure. In our case, the document specifying the existence of the literal obligations does not generate obligations. He only ascertains the existence of an obligation born through a contract such as stipulation or mutuum. And now, as a conclusion, the creation of literal obligations by Emperor Justinian coincides with the conclusion of a long process started in ancient times with the consecration of solemn contracts. This process was completed at the moment when Roman law detached itself from the rigorous formalism specific to an old era, and the distinction was made between the act generating legal effects, negotiorum gestio, and the act ascertaining the manifestation of will, instrumentum probationis. The result of this process inspired the Roman jurists to create suitable legal instruments for the conduct of business and to offer applicable models in any society characterized by the existence of the exchange economy. Thank you very much.
Thank you as well, Professor. So I think the communication was comprehensive and extensive, and I think that you proved very well the point that you wanted made. If we have no questions coming from either the online participants or the present participants, then I would move to give the floor to Professor Emilia Mădulărescu, who is online with us. Okay, so Professor Mădulărescu is a former judge at the Court of Appeal of Bucharest, and she is also a lecturer in our faculty, so welcome, Professor. The communication today will be in Romanian, the limits of the legality control made within the action of annulment in the arbitration decision. So, Professor, you have the floor. Thank you.
Mulțumesc. Mulțumesc de invitație. Bună ziua. Felicitări pentru modul de desfășurare a acestei conferințe. Este o onoare să fiu aici alături de dumneavoastră. Voi prezenta în funcție de limitele controlului de legalitate realizat în cadrul acțiunii de anulare a hotărârii arbitrare din perspectiva practicii judiciare. Am plecat în redactarea acestui articol de la contextul economic dinamic pe care îl traversăm, care impun o reorientare a părților în promovarea unor metode de soluționare alternativă a cauzelor, iar arbitrajul este la îndemâna acestora și este o cale de urmat pentru asigurarea unui act de justiție pentru obținerea satisfacerea doleanțelor care rezultă din raporturile juridice pe care și le-au încheiat. Am pornit, așa cum am spus, de la contextul economic și de la faptul că doctrina a statuat că arbitrajul este o metodă de soluționare a disputelor prin care părțile convin ca litigiile dintre ele să fie soluționate de un tribunal arbitrar privat, iar nu de instanțele de drept comun. Prin urmare, părțile sunt cele care stabilesc această metodă de soluționare, iar în situațiile în care au ales această metodă de soluționare a disputelor, aceasta nu mai are pentru ele un caracter de recomandare, ci este obligatorie. Putem spune că arbitrajul este o instituție complexă, întemeiată pe consimțământul părților, iar acest consimțământ se poate limita nu numai la consemnarea acordului ca soluționarea litigiilor dintre ele să se realizeze pe calea arbitrajului, dar poate include și procedura de urmat în soluționarea unor astfel de dispute. Am pornit sau am arăta că fundamentul arbitrajului este reprezentat de convenția arbitrară bazată pe autonomia de voință. Prin urmare, părțile sunt libere să recurgă la arbitraj sau nu, iar dacă optează pentru astfel de metodă de soluționare, pot să le organizeze de cuvință, cum doresc, însă legea le impune o limitare, limitare care se regăsește în articolul 541 aliniat 2 din Cod de Procedură Civilă, în sensul că ele trebuie să nu fie contrare ordinii publice sau dispozițiilor imperative și dispozițiilor nu sau, deși dispozițiilor imperative ale legii. Libertatea contractuală a părților alături de celeritate și flexibilitate, dar și de costurile reduse pe care le generează o astfel de metode de soluționare alternativă a cauzelor, au impus această procedură ca mijloc de soluționare. Însă, pornind de la autonomia de voință în obținerea hotărârii arbitrare, a impus totuși o restrângere a intervenției și controlului instanțelor judecătorești, aspect care este reflectat în motivele limitativ prevăzute de Cod de Procedură Civilă pentru a promova acțiunea în anulare. Ele se regăsesc în articolul 608 din Cod de Procedură Civilă. Prin urmare, acțiunea în anulare are scopul de a realiza un control judecătoresc în limitele prevăzute de art 608, Cod de Procedură Civilă, și o să arătăm mai pe larg că nu poate sau nu privește o astfel de acțiune reexaminarea hotărârii arbitrare sub aspectul soluționării fondului litigiului, tocmai pentru că o convenție arbitrară are la bază autonomia de voință și nu poate fi asimilată apelului. Altfel spus, acțiunea în anularea hotărârii arbitrare nu poate reprezenta o poartă pentru reexaminarea în fond a litigiului. Dacă este sau nu este o cale de atac, ne-a răspuns Înalta Curte de Casație și Justiție într-un recurs în interesul legii în anul 2001, în care a spus că acțiunea în anulare îndreptată împotriva hotărârii arbitrare constituie o cale de atac, iar în considerent a spus că în accepțiunea legiuitorului, soluționarea litigiului la tribunalul arbitral constituie o judecată în fond, iar acțiunea în anulare, fiind o cale de atac, nu poate determina o reexaminare cu caracter devolutiv. Prin urmare, între acțiunea în anulare și apel nu există semn de egalitate. Rațiunea acestei interpretări este dată și de ansamblul reglementărilor care se referă la desființarea hotărârii arbitrare. Putem spune că prin hotărârea arbitrară, prin acțiunea în anulare împotriva hotărârii arbitrare, scuzați-mă, suntem în prezența unui control judecătoresc care se realizează pe cale de acțiune în primă și ultimă instanță, deoarece hotărârea judecătorească pronunțată în acțiunea în anulare are drept cale de atac doar recursul, așa cum statuează prevederile articolului 613. Concluzia se desprinde și din faptul că completul care soluționează este cel care este prevăzut pentru judecata în primă instanță, dar și din motivele de anulare a hotărârii arbitrare, așa cum sunt ele enumerate limitativ de articolul 608. S-a statuat că niciunul dintre motivele prevăzute de articolul 608 nu dă dreptul instanțelor de judecată să cerceteze modul în care a fost soluționat fondul pricinii de către tribunalul arbitrar, ci numai să verifice dacă sunt respectate sau au fost respectate condițiile de formă ale arbitrajului. Altfel spus, acțiunea în anulare constituie doar o cale de control judecătoresc asupra hotărârii arbitrare cu două obiective bine determinate. Conformitatea hotărârii arbitrare cu convenția arbitrară, precum și respectarea principiilor fundamentale ale procesului civil. S-a statuat în practică că este inadmisibilă invocarea unor aspecte care vizează fondul pricinit, respectiv modul de interpretare de către instanța arbitrară a probelor administrate pentru soluționarea fondului, sau interpretarea actului juridic de dus judecății, întrucât acesta este apanajul doar al tribunalului arbitrar, al instanței arbitrare. Prin urmare, validitatea clauzei compromisorii este independentă de contractul în care este inclusă. Acest lucru este statuat și de dispozițiile art. 550, aliniat 2 pentru arbitrajele interne, respectiv 1113, aliniat 3 pentru arbitrajele internaționale. Tot în practică s-a stabilit că motivele de nulitate sau de reziliere, rezoluționarea contractului principal, nu se răsfrâng ca principiu asupra clauzei compromisorii. Însă, există unele motive de nulitate care s-ar răsfrânge și asupra clauzei compromisorii, cum ar fi lipsa de capacitate sau viciile de consimțământ, însă, ca regulă generală, nulitățile privesc doar contractul principal și nu clauza compromisorie. Concluzia este că controlul realizat prin intermediul acțiunii în anulare este unul de legalitate, iar nu unul de temenicie a hotărârii arbitrare. Articolul 608 aliniat 2 statuează că nu pot fi invocate ca motive de anulare neregularitățile care nu au fost ridicate în condițiile articolului 592 aliniat 1 și 3 sau care pot fi remediate printr-o cerere de lămurire, completare sau îndreptare a hotărârii arbitrare. Astfel, într-o decizie de speță, s-a stabilit că acțiunea în anulare a hotărârii arbitrare nu poate fi exercitată pentru alte motive decât cele statuate de lege, pentru considerentul că partea adversă este de rea credință. De asemenea, exercitarea dreptului de acces la arbitraj nu poate fi calificată ca o faptă ilicită și pe cale de consecință ca o exercitare abuzivă a dreptului. Înalta Curte de Casație și Justiție, referitor la interpretarea articolului 608, Cod de procedură civilă, a reținut că, deși instanțele judecătorești au plenitudinea de competență, legiuitorul a derogat de la acest principiu, încuvințând părților dreptul de a conveni printr-un contract de compromis ca litigiile să fie soluționate de către arbitrii prin parcurgerea procedurii arbitrare caracterizată prin celeritate. Totuși, ca părțile să nu fie private de garanțiile procesuale pe care le conferă procedura jurisdicțională, cu atât mai mult cu cât hotărârea arbitrală este ea însăși un veritabil act jurisdicțional, producând aceleași efecte ca și hotărârea judecătorească, Codul de procedură civilă prevede o cale de atac specială împotriva hotărârilor arbitrare, pentru motivele, așa cum am spus anterior, expres și limitativ prevăzute de art. 608. Nulitățile prevăzute de art. 608 sunt de ordine publică și nu pot fi acoperite prin voința părților, care nu pot stipula prin compromisul încheiat că renunță la nulitățile prevăzute de lege pentru hotărârile arbitrare. S-a reținut în jurisprudența instanței supreme că este de ajuns ca o singură dispoziție din hotărârea arbitrară să cadă sub incidența vreuneia dintre cazurile prevăzute de la art. 608, pentru ca întreaga hotărâre arbitrară în totalitate să fie nulă, indiferent dacă de soluția acelei dispoziții ar depinde sau nu soarta celorlalte, cu atât mai mult cu cât diversele dispoziții din hotărâre s-ar afla într-o dependență oarecare. O atare reținere s-a întemeiat pe natura însăși a acțiunii în anulare, care nu poate fi asimilată în niciun fel căilor de atac ordinare, care permit desființarea, respectiv casarea în parte a hotărârilor judecătorești nefondate, întrucând fiind calificată ca o cale de atac specială prevăzută de lege, va duce la declararea nulității hotărâre arbitrare în totalitatea sa. Tocmai pe argumentul că motivele sunt prevăzute în mod expres de articolul 608, sunt tot atâtea motive de încălcare a garanțiilor procesuale ale părților în litigiu care afectează actul atacat în ansamblu său. S-a susținut că sancțiunea anulării în parte a hotărârii arbitrare nu este o simplă exprimare a legii, ci ține de însăși natura acestei căi speciale din materia arbitrajului. Totuși, această soluție în alte curți de casație și justiție a fost nuanțată într-o altă decizie de speță prin raportare la principiul disponibilității, care guvernează procedura civilă în ansamblu său, însă și procedura arbitrală. În acest sens, Înalta Curte de Casație a reținut că, deși dispozițiile articolului 613 aliniat 3 prevăd anularea sentinței arbitrare în totalitate ca urmare a admiterii acțiunii anularea hotărârii arbitrare, sintagma folosită de legiuitor nu poate fi interpretată în sensul anulării în toate cazurile, în întregimea hotărârii arbitrare atacate cu acțiune în anulare, întrucât în acest mod s-ar ignora, în mod nepermis, inter alia, principiul disponibilității și s-ar da dovadă de un formalism excesiv neavut în vedere de către legiuitori. În speță, s-a statuat că reclamanta a investit în instanța de judecată cu o acțiune în anulare, prin care a criticat numai dispozițiile tribunalului arbitrar referitoare la compensația legală și doar în aceste limite putea fi analizată acțiunea în anulare cu respectarea principiului disponibilității. S-a statuat sau s-a reținut că atâta vreme cât partea înțeles să atace hotărârea arbitrară în mod expres, doar în parte, exclusiv cu privire la constatarea stingerii în întregime a creanței reclamantei ca urmare a compensației legale, fără a contesta soluția pe fond asupra acțiunii arbitrale, hotărârea arbitrală comunicată părților cu privire la acest aspect este definitivă și obligatorie, fondul pretențiilor reclamantei necontestat în acțiunea anulare, nefiind în măsură a fi afectată de cea subsecventă a aplicării efectelor compensației legale. Similar instanțelor judecătorești, tribunalele arbitrare pot pronunța încheieri sau hotărâri care pot fi atacate separat cu acțiune în anulare, în cazuri de asemenea enumerate expres de articolul 594 aliniat 1. Referitor la aceste încheieri, în practică s-a considerat că încheierea prin care tribunalul arbitrar a respins cererea de suspendare a litigiului până la soluționarea unui alt dosar de arbitraj, al doilea dosar fiind soluționat prin sentință arbitrară, atacată cu acțiune în anulare, este o încheiere care nu se înscrie în niciuna din ipotezele prevăzute de articolul mai sus menționat, 594, aliniat 1. Instanța de anulare, fiind investită cu soluționarea unui incident procedural de natura a nu afecta sub aspectul analizei fondul acțiunii arbitrale, nu este susceptibilă de a fi atacată cu acțiune în anulare reglementată de art. 608. Din punct de vedere procedural, în practică nu s-au evidențiat aspecte controversate. Dispozițiile articolului 608 aliniatul 2, stabilind că orice excepție privind existența sau validitatea convenției arbitrare poate fi introdusă cel mai târziu la acel termen sau dacă nu s-a stabilit un termen mai scurt. Din conținutul articolului 608 reiese că unele motive de nulitate sunt similare celor din procedura civilă, astfel încât nu ridică în practică probleme deosebite și ne vom opri numai asupra elementelor specifice procedurii frecvent întâlnite în practica judiciară. Articolul 608, aliniat 1, litera A, face trimitere ca motiv de nulitate a acțiunii arbitrale, a hotărârii, scuzați-mă, arbitrare, litigiul nu este susceptibil de soluționare pe calea arbitrajului, astfel încât el ar trebui să fie de competență exclusivă a instanțelor judecătorești sau un alt organ de jurisdicție pentru a fi în prezența, pentru a fi justificat un astfel de motiv. Prin raportare la prevederile articolului 542, reținem că legiuitorul a exclus din sfera arbitrajului litigiile privind starea civilă, capacitatea persoanelor, dezbaterea succesorală, relațiile de familie, precum și dreptul asupra cărora părțile nu pot să dispună. Totodată se constată că și statul sau autoritățile publice au facultatea de a încheia convenții arbitrale dacă sunt autorizate prin lege sau prin convenții la care România este parte, după cum legiuitorul a dat posibilitate și persoanelor juridice de drept public care au în obiectul lor de activitate și activități economice să încheie convenții arbitrare, cu excepția situațiilor în care legea sau actul lor de înființare ori de organizare prevede în mod expres. Astfel, se poate constata că implicarea directelor a statelor și autorităților publice în activități economice au impus o revizuire a abordării prin care se recunoștea că se poate recurge la arbitraj doar în temeiul convențiilor internaționale la care România este parte. Se poate constata că s-a confirmat de către doctrină și jurisprudență că și autoritățile publice pot încheia convenții arbitrale dacă au fost împuternicite și legea prevede în mod expres că pot face acest lucru. Pentru că articolul privește practica judiciară de referitoare la limitele arbitrajului sau în practică, la întrebarea dacă prevederile articolului 7 alineat 3 din norma 18/2017 privind procedura de soluționare a petițiilor referitoare la activitatea societăților de asigurare și reasigurare și brokerilor de asigurare emise de Autoritatea de Supraveghere Financiară, conferă sau nu Tribunalului Permanent arbitral instituționalizat competența de soluționare a neînțelegerilor izvorâte din asigurări, cazul concret al terțului păgubit în urma unui accident, această întrebare a primit răspunsul că un astfel de litigiu nu este susceptibil de soluționare pe calea arbitrajului, întrucât nu există o convenție arbitrală sau operabilă. S-a reținut că, deși când se constată că aceste dispoziții reglementează procedura de soluționare a petițiilor referitoare la activitatea societăților de asigurare. Prin raportare la dispozițiile articolului 542, se poate constata că litigiul este unul patrimonial care privește într-adevăr materia asigurărilor, care nu face parte din categoria de litigi exceptate de legiuitori. Pe de altă parte, petenta nu se află în niciuna din situațiile în care dreptul său de a participa la arbitraj să fie supus unor condiții restrictive, ea fiind o societate de drept privat. Pentru a putea răspunde însă, sau să fie complet răspunsul, s-a avut în vedere și prevederile articolului 608 aliniatul 1 litera B, respectiv dacă a existat o convenție arbitrală. Așa cum am arătat anterior, la baza arbitrajului se află convenția părților, înțelegerea lor de a recurge la această modalitate de soluționare a litigiilor, iar dacă această convenție nu există, este nulă ori inoperabilă, arbitrajul nu poate să se organizeze și să desfășoare valabil fără o astfel de convenție valabilă. Reținând această prevedere, s-a concluzionat că norma numărul 18 anterior evocată nu întrunește condițiile pentru a constitui temei al competenței arbitrare și nu suplinește lipsa acordului ambelor părți. Chiar dacă s-ar considera că prin petiție se înțelege orice pretenție pe care ar putea să o aibă un terț prejudiciat împotriva unei societăți de asigurare, faptul că în cuprinsul acestea se menționează că în vederea soluționării pe care amiabilă a disputelor dintre societăți, brokeri și asigurați, contractați, beneficiari, persoane prejudiciate sau reprezentanții acestora la solicitarea uneia dintre părți, se utilizează metodele alternative de soluționare a litigiilor, respectiv în cazul persoanelor fizice, entitatea de soluționare alternativă a litigiilor, înseamnă că arbitrajul este permis în situația persoanelor juridice, dar aceasta nu înseamnă că poate fi aplicat în mod obligatoriu ca urmare a alegerii unui reclamant, fără ca părâta din acțiunea arbitrară să fie de acord cu soluționarea litigiului de o instanță arbitrară. S-a considerat că dispozițiile sau că potrivit tezei finale ale aliniatului 3 din articolul 7, care prevede că soluționarea amiabilă sau prin intermediul metodelor de soluționare alternativă a litigiilor nu limitează dreptul părților de a se adresa instanțelor de judecatabilitate, înseamnă că părțile au posibilitatea să se adreseze nu doar instanțelor de judecată pentru soluționarea diferendului dintre ele, ci și unei instanțe arbitrare, aspect care întărește concluzia că soluționarea de către instanță arbitrară este posibilă, dar numai dacă părâta este de acord cu astfel de soluționare, dat fiind că nu există nicio dispoziție legală care să oblige părâta să se supună unei astfel de proceduri. Nici dispoziția articolului 7, nici din normă, nici prin raportare la art 80, OG, numărul, 38/2015, care definește în articolul 3 aliniat 1 litera A consumatorul ca fiind persoana fizică sau grupul de persoane fizice constituite între asociați, nu pot fundamenta soluția de stabilire a competenței în favoarea tribunalului arbitrar. De asemenea, într-o situație similară, s-a reținut că norma numărul 18/2017 a Autorității de Supraveghere
nu poate reprezenta o cumplire a lipsei unei convenții arbitrare în forma scrisă, astfel cum este prevăzută de articolul 548 Cod de procedură civilă, întrucât în Codul Civil stabilește în termen clar modalitățile în care poate avea loc încheierea contractului, și anume negocierea de către părți sau prin acceptarea fără rezerve a unei oferte de a contracta. Ori, în speță, un astfel de acord între cele două părți nu a existat. Acceptarea că norma numărul 18 ar complini consimțământul nu doar a uneia dintre părți, ci a ambelor părți, ar conduce la confirmarea abuzului de libertate contractuală. Un alt motiv de anulare a hotărârii arbitrare care a comportat diverse aplicabilități în practica judiciară este cel în cel de la litera H, în care se specifică că hotărârea arbitrală este anulată sau anulabilă dacă încalcă ordinea publică, bunele moravuri ori dispozițiile imperative ale legii. S-a statuat că în interpretarea acestui articol, ceea ce interesează în analiza acestui motiv este dacă norma ce se susține a fi încălcată de către instanța arbitrală are caracter imperativ sau nu. Norma imperativă fiind de drept substanțial, fie de drept procesual, ce ar fi trebuit încălcate de Curtea de Arbitraj pentru a atrage incidența motivului de anulare invocat, trebuie să prescrie o anumită conduită încălcată de părți, dar acceptată de către instanță, sau să interzică o anumită conduită pe care Curtea de Arbitraj să o fi permis. Înalta Curte de Casație și Justiție, cu privire la acest motiv de desființare a hotărârii arbitrare, a subliniat diferența dintre noțiunile enumerate de articolul 608 litera H, arătând că noțiunea de ordine publică nu este identică cu cea de normă imperativă, iar bunele moravuri vizează ocrotirea unui interes general și semnifică un ansamblu de reguli impuse de o anumită morală socială existentă la un moment dat și într-un anumit loc, care, în paralel cu ordinea publică, reprezintă un standard în funcție de care sunt apreciate comportamentele umane. Prin urmare, pentru admisibilitatea acestui motiv de anulare a hotărârii, trebuie făcută dovadă că s-ar fi dus atingere unor norme de ordine publică ori dispozițiilor imperative ale legii prin hotărârea arbitrală. S-a statuat în practică, într-o decizie de speță, că dispozițiile articolului 3 aliniat 3 din legea 31/90, cele ale articolului 1270, respectiv 1445 Cod Civil, nu sunt imperative, ci dispozitive, ele reglementând principii care nu se confundă cu normele imperative, ci impun o anumită conduită a părților. Nici excepția lipsei de interes în promovarea acțiunii arbitrare nu poate constitui un motiv de nelegalitate a hotărârii arbitrare, care să se circumscrie dispozițiilor art. 608 aliniat 1 litera H, fiind aspecte de fond care exced controlul de legalitate ce poate fi făcut în acțiunea în anulare. În concluzie, controlul exercitat de către instanța judecătorească asupra hotărârilor arbitrare este limitat la aspectele de legalitate, excluzând temeinicia hotărârii arbitrare. Altfel spus, instanța nu are competența de asupra interpretărilor și considerentelor de oportunitate ale instanței arbitrare, ceea ce conferă o flexibilitate sporită procedurii indicate de soluționarea alternativă a litigiilor. Optica de mai sus a concretizat relativ recent și în soluția pronunțată de Înalta Curte de Casație și Justiție, completele pentru soluționarea recursurilor în interesul legii, în decizia numărul 1
respectiv 31 din 31 a 1 a 2022, prin care a stabilit că în interpretarea și aplicarea unitară a dispozițiilor act 603 alinia 3 din Codul de Procedură Civilă, sintagma după verificarea respectării condițiilor vizează verificarea condițiilor formale ale hotărârii arbitrare, iar nu cele de fond. Prin urmare, motivele pentru care poate fi anulată hotărârea arbitrală sunt strict prevăzute de lege, însă, în practica judiciară se poate constata o tendință de a se încerca eludarea acestui caracter limitativ al acestora, petenții încercând să readucă în discuție elementele vizând teminicia hotărârii contestate. Jurisprudența instanțelor s-a pronunțat însă, în mod constant, după o analiză a acestor motive, de respingere a acestor tentative pe fondul cererii, iar nu pe inadmisibilitatea cererii în anulare. Mulțumesc, îmi cer scuze că a fost exhaustiv. Am încercat să mai arunc timp.
Da, e foarte adevărat. Thank you very much, Professor, for the very comprehensive presentation that you have given us, and it was indeed very interesting and very well structured and pointed, in the sense that it gathered all of the necessary elements in order to file a very, very strong action annulment. I think that next off I can have lecturer. Sorry. D'accord. Alors, bon, je vais donner la parole à notre invité. I will give the floor to our guest today, to our guest speaker, keynote speaker today, who wants to add a few things.
Very, very few remarks. First, no, of course, I could not understand what had been said, but I'm quite sensitive to this topic. As you know, probably Paris is a very important place of international arbitration. That's why you can imagine how French authorities are committed to limit the control of legality by the national judge on arbitration decisions. And so, according to French law, this control is very, very limited. But as you know, perhaps also, that the relationship between the Court of Justice and arbitration is not so easy because there are some suspicion from the Court of Justice vis-à-vis arbitration. But we can say that it's not so clear decision, but the ruling of the Court of Justice EcoSuisse China, which dates back to 1999, we can interpret this decision as a ruling that this limited control by the national judge on arbitration decision was compatible to the EU law. The problem with EU law is that, according to the case law of the Court of Justice, arbitration instances, arbitration bodies, I don't know, are not considered as national courts entitled to refer questions to the Court of Justice. That's the reason of the suspicion by the Court of Justice, but finally we can say that this decision of EcoSuisse China dating back to 1999 admit the compatibility with this limited control of legality control by the national judge on arbitration decisions with the community law, EU law. But sometimes, we were quite disturbed by
by some position of the European Commission or even the Court of Justice. But at the end of the day, we can say that in order to protect, of course, the importance of the international arbitration place like Paris, but Stockholm as well, it's important for the EU Commission or the EU Court to admit this limited control of the national judge on arbitration decisions. Thank you very much.
Thank you as well, Professor. I think I can invite Ms. Simona Guțiu, who is right now a public notary, if I am not mistaken. Also, we have the pleasure to have her in our faculty body in our faculty body for a very long time, teaching with us. So today her intervention will be about the taxation of personal income obtained from real estate transactions. So, Professor, thank you. You have the mic.
Hello. I'm happy to join this beautiful conference, very interesting the topics. I will try to be very concise from many perspectives. The details of my subject you will find in the paper. I draw the attention in this paper regarding a very new topic, a topic legal topic that has been amended and is in place, is applicable since the 1st of January 2023, and it regards the taxation of the income of the private individuals from the real estate transactions performed in Romania. These new rules are actually in the sense of increase of the taxation to the previous years. And this leads actually in some cases to 3 times the increase of the quota for the taxation for transfer of the real estates of the private individuals. So and this, of course, was quite a shock for some people in the beginning when the government actually, because the government enacted a government ordinance by which the fiscal code has been amended. This government ordinance has not been yet or so far approved, confirmed by the parliament. However, it is applicable, as we all know. In short, the new rule introduces new criteria like new taxation quotes, rates like 1 or 2 or 3%, depending on new introduced criteria, and this is the duration of holding the property in the personal patrimony. Until this new rule, the real estate transactions were also taxed. However, it was an exoneration and tax exempt for a threshold of 450,000 lei, and the taxation was applicable only of 3%, was applicable only to the difference between the value of the transaction and 450,000 lei. This means more or less 90,000 euro. This threshold of non-taxation has been removed, cancelled by this new rule, and now the new rule says that all transactions are taxable, and this taxation is between either 3% of the whole value of the transaction. So far, so good. We understood this is the new rule. However, the fiscal code
has not been in detail amended. This means that there are lots of situations not covered expressly by the new rule, and there is a lot of uncertainty on the market for the competent persons and for the taxpayers on how to determine correctly the tax rate for the real estate transactions with private individuals. And here, in my paper, I identified some zones, some uncovered zones that are interesting to be addressed to the Ministry of Finance and the tax authorities in order to come with clarifications, in order to be able to apply correctly the tax and to not to overtax situations that that seems to be unclear. One of the problems, the technical problems in respect of this new rule is also the fact that the norms, the methodological norms of the application of the fiscal code has not been adapted so far, so it is pending. So in this context, the people have not been stopped to, they did not suspend the transactions, they are doing the transactions. And in some cases, the notary publics are in the difficult situation to apply or to apply the quota that for which they do not have enough clarity in the legal framework. Currently, the new law states that for the immovable hold for a longer period than 3 years, the tax rate is 1%. For the immovables, for the real estate hold for a period less than 3 years, the tax rate is 3% of the value of the transactions, of course. There are some open topics to which we cannot find a clarity in the legal framework, and we have to deal with them because in Romania the notary publics are obliged to determine to cash in and to be liable for the payment of the tax income in the name and on behalf the taxpayers to the state budget. So it's a huge responsibility, which, with which some of us in these difficult situations are quite challenging. One of the questions is the Romanian text of law uses the term hold, deținere. And legally speaking, it's not clear whether whether the intention was to rely or to rely on the term actually to hold as an owner the respective good. And secondly, the topic that I have met also in practice is, for instance, an allotment through which two persons, two joint owners, have decided to allot the good and to become from joint owners to exclusive owners for their quota. The question is, from this date, from the date of the allotment, it is considered that the exclusive right over the quota has been born from this date of the allotment agreement, notarized, of course, for the real estate, or we can consider that the ownership right exists prior from the date on which they became joint owners, because there is no transfer from a patrimony to another. The patrimony is the same. The parties actually only
only decide to allot to demerge and allot a good in order to have two distinct and exclusive property rights. And the question to be raised is what if a person, after executing an allotment agreement, wants to sell that good? It is considered that the date of the allotment is the holding date or the previous date by which the previous act or legal deed by which it became co-owner, sale agreement or exchange or donation or whatsoever legal deed by which it become owner. Unfortunately, there is no text of law replying or answering to this question. And we have to go then to also to interpret this, this norm by corroborating the fiscal provisions, tax provisions with the civil code. According to the new civil code, the allotment, partajul, in Romanian, has a constitutive right and not a declarative right. This means that for the exclusive property, it is considered that the date of acquiring, it is the date when the exclusive right has been born in a patrimony of the owner. If we go by this, by this very strict interpretation that that the ownership right, the exclusive ownership right, is the object of the real estate transaction, and the date of constituting this right is the date of the allotment, then it is clear that the time will start to run, will commence to run from this date. And of course, it has an impact because normally the people are staying in joint ownership in the private, in their private lives for a longer period of time, which impacts, of course, the application of 1 or 3%. If we go and we interpret in a more relaxed or less strict this fiscal interpretation, we could also say that by allotment, no transfer has been occurred, but only the parties have decided to exit the ownership and to become sole exclusive owners, and this cannot lead to the conclusion that the ownership right, regardless of the quota or exclusive right, has been actually initially constituted in their patrimonies on the date of acquisition, the initial acquisition, and this will lead, of course, to another taxation. However, these are interpretation. We have no practice, no norms, nor secondary explanations or orders from the Ministry of Finance, and in this case, we should, try to interpret the tax provision in good faith, and to take into consideration one of the basic principles in tax law, by which it is stated that in case of uncertainty, uncertain or unclear tax provisions, this will be interpreted in the favor of the taxpayer. Yeah, of course, the theory looks great. The practice, we would love to see also that the tax inspectors remember this basic principle by which the taxpayer is considered, presumed to be in good faith, respectively. The text of law, the unclear text of law, will be interpreted in their favor and not against them. So, of course, if there is a wrong application or determination of the tax rate, the fiscal code offers a remedy by which
the taxpayer, the notary, may apply for a rectification, for a new application by which it will correct the wrong initial application. And my conclusion is that before, as a lege ferenda, as a future recommendation for our bodies, legislative bodies, would be to try to offer to the person who are supporting and applying these tax sensitive tax issues for the state, is to offer them also a concise and clear legal framework in order not to create a negative impact to the budget and also to the taxpayers, because both can be harmed by an incorrect application of the tax rates. Needless to say that a specialist in civil law, like a notary, is not a specialist in taxation, and this is another burden, a practical burden that should be also considered, an additional reason for which the framework should be clear, in order to help the people to apply and to make a good collection for the state. Thank you.
Thank you so much, Professor. I think the issue of predictability in establishing fiscal legislation, especially towards fixation of taxes, is an issue that I think our guest here today has established is not yet very on point in other countries as well, such as France. So in change of doctrine regarding the taxation of poker games, for instance, as well as the Romanian state apparently today has, not apparently, but has today an issue pertaining to taxation of real estate. Okay, next off, I would like to invite our colleague, Ms. Mihaela Marica, who is a lawyer, who is also a member of our faculty team, who today will be presenting brief commentaries on disciplinary sanctions with emphasis on the written warning, as well as elements of the comparative law. So, Ms. Marica, please.
Bună ziua, înainte de toate. Mihaela Marica sunt, după cum spuneai, lector la Facultatea de Drept, la Catedra de Dreptul Muncii, și ca atare comunicarea științifică vizează domeniul legislației muncii, mai exact câteva considerații referitoare la sancțiunile disciplinare prevăzute de Codul Muncii. Domeniul disciplinei muncii este unul destul de complex, atât sub aspect normativ cât și jurisprudențial, și în acest context am încercat o trecere în revistă a sancțiunilor disciplinare prevăzute de Codul Muncii, cu accent pe problemele doctrinare și jurisprudențiale identificate în cazul avertimentului scris ca cea mai simplă dintre sancțiunile disciplinare dispusă de către angajator, de asemenea pentru a contura o imagine de ansamblu a acestor instituții care formează domeniul disciplinar. O analiză de drept comparat a fost avută în vedere prin raportare la state precum Bulgaria, Marea Britanie, Israel, Elveția și Belgia. În virtutea prerogativei disciplinare care este conferită de lege angajatorilor, aceștia trebuie să aibă capacitatea de a-și disciplina salariații care săvârșesc abateri disciplinare și care cumva acționează într-o manieră care le afectează exercițiul funcțiilor prin aplicarea unor sancțiuni care să combată cumva aceste acte de indisciplină. Sub aspectul categoriilor de sancțiuni, acestea sunt expres prevăzute în Codul Muncii. Există o enumerare limitativă a acestor sancțiuni în articolul 248 alineatul 1. Legiuitorul a optat practic pentru a lupta împotriva indisciplinei prin aplicarea unor măsuri preponderent punitive, dacă putem spune așa, cu excepția avertismentului scris, care are un efect precumpănitor moral. Dacă sub aspectul definițiilor textul normativ este destul de clar, nu același lucru se întâmplă în cazul faptelor care pot atrage aplicarea de sancțiuni disciplinare, pentru că ele nu sunt evidențiate în textul normativ. Este un atribut lăsat angajatorilor, care în funcție de specificul activității definește fiecare faptă care poate să constituie abatere și care, pe cale de consecință, să atragă aplicarea de sancțiuni disciplinare. Cum o face angajatorul există, pentru că el este cel care trebuie să individualizeze sancțiunea disciplinară. Există o serie de criterii puse la dispoziție de Codul Muncii în articolul 250, care statuează că angajatorii în procesul de individualizare a sancțiunii disciplinare trebuie să aibă în vedere următoarele aspecte: împrejurările în care fapta a fost săvârșită, gradul de vinovăție al salariatului, consecințele pe care le produce fapta, precum și eventualele sancțiuni disciplinare care au fost aplicate anterior salariatului. Acum, în practică s-a considerat oportun ca în regulamentul intern, pentru că acolo este locul unde trebuie să fie incluse aceste fapte, în regulamentul intern nu ar trebui să fie identificate pentru fiecare faptă și sancțiunea aplicată, în contextul în care instanțele au decis în mod constant că dacă se menționează, de exemplu, în cazul întârzierii la serviciu, dacă se menționează și că este sancționată cu avertisment, indiferent de paguba produsă asupra angajatorului, el nu poate aplica o sancțiune mai severă. Tocmai de aceea, recomandarea este, din punct de vedere al eficienței practice, să se includă doar faptele, nu și sancțiunile, și să rămână la aprecierea angajatorului în funcție de aceste criterii pe care legea le pune la dispoziție. În ceea ce privește enumerarea sancțiunilor disciplinare, articolul 248 din Codul Muncii stabilește exhaustiv, printre sancțiunile disciplinare, avertismentul scris, retrogradarea din funcție, cu acordarea salariului corespunzător funcției în care s-a dispus retrogradarea pentru o perioadă care nu poate să depășească 3 luni, într-un procent cuprins între 5 și 10%, reducerea salariului de bază pe o perioadă 1-3 luni cu același procent și a indemnizației de conducere, dacă este cazul să vorbim despre o funcție de conducere, în același procent și pentru aceeași perioadă. Și cea mai gravă dintre cele sancțiuni este cea referitoare la desfacerea disciplinară a contractului de muncă. Aș avea un aspect de subliniat foarte important legat de posibilitatea suspendării contractului individual de muncă ca sancțiune disciplinară, pentru că până la amendamentele aduse Codului Muncii prin legea 40 din 2011, când au intervenit cele mai multe modificări, suspendarea contractului individual de muncă era o ipoteză legală când vorbeam de sancțiunile disciplinare. După această modificare, suspendarea nu mai este posibilă, așa încât nici prin acord colectiv nu se poate include o astfel de ipoteză ca fiind legală. Atâta timp cât am văzut textul normativ de la 248, este un text imperativ și enumerativ. Tot astfel, suspendarea contractului de muncă nu mai este posibilă nici pe durata procedurii de cercetare disciplinară, pentru că exista această opțiune ca atunci când se declanșa cercetarea, angajatorul să poată suspenda contractul. A intervenit Curtea Constituțională printr-o decizie în acest sens, considerând că măsura respectivă este o măsură mult disproporționată în raport cu dreptul la muncă, drept constituțional. Pe bună dreptate, pentru că erau înregistrate foarte multe abuzuri în practică, în sensul în care se suspendau contractele individuale de muncă pe toată durata suspendării, care putea să ajungă și la 6 luni și la sfârșitul cercetării se considera că fapta nu a fost săvârșită cu vinovăție și atunci era aplicat un simplu avertisment scris. și salariatul era lipsit de cele două efecte importante ale contractului, plata salariului și executarea muncii. De altfel, ca o părere personală, aceste decizii, aceste modificări care au intervenit, au știrbit în mod serios prerogativa disciplinară despre care vorbeam anterior, că se bucură de o consacrare expresă în textul normativ și astăzi s-au limitat foarte mult posibilitățile în această privință. Suspendarea a rămas totuși o practică legală în alte state, de exemplu în Israel. Este o practică legală doar în condițiile în care se stabilește prin contractul colectiv de muncă, întrucât nu se găsește printre standardele generale. Și ca o măsură de protecție, aici se mai prevede că salariatul primește, practic, pe toată această perioadă, o jumătate din salariul avut, cu mențiunea că dacă este achitat la sfârșitul cercetării, îi se plătește tot salariul retroactiv. Tot în dreptul comparat, în UK, de exemplu, sancțiunile disciplinare sunt enumerate în codurile de practică de la avertizare, mustrare, amendă, deduceri, suspendare preventivă, transfer, până la cea mai grea dintre ele, concedierea disciplinară. De asemenea, în Elveția, Codul Muncii dă dreptul angajatorului de a stabili reguli de muncă privind ordinea internă, incluzând chiar și sancțiunile disciplinare. Un sistem de drept aparte îl găsim în Bulgaria, unde sancțiunile care pot fi aplicate salariaților sunt doar avertizmentul de concediere și concedierea disciplinară. În afara acestor elemente, în afara acestor sancțiuni, nu se pot aplica și altele, pentru că, la fel, și aici textul normativ are caracter imperativ. Avertizmentul, scris ca cea mai simplă dintre sancțiunile disciplinare, este, sub aspect conceptual, o măsură disciplinară asociată prioritar cu abaterile de mică importanță și neintenționate ale salariatului, constând într-o notificare scrisă prin care îi se aduce practic la cunoștință salariatului că a săvârșit o abatere, că a săvârșit o încălcare a normelor, a contractului colectiv și contractului individual de muncă sau, după caz, a nerespectării dispozițiilor superiorilor ierarhici. Aici se pune problema în acest context dacă, prin raportare la dreptul intern, dacă avertismentul verbal totuși produce efecte juridice. S-a considerat în literatură că textul normativ precizează face trimitere expresă la avertismentul scris și atunci o simplă mustrare sau avertisment verbal nu poate să fie considerată ca fiind legală. Iar în ceea ce privește aspectele controversate care au fost ridicate în practică legat de aplicarea acestei sancțiuni mai puțin severe a avertismentului scris, s-au identificat următoarele. Pornind de la articolul 251 din Codul Muncii, care stabilește că sub sancțiunea nulității absolute nicio măsură, cu excepția avertismentului scris, nu poate să fie dispusă mai înainte de efectuarea unei cercetări disciplinare prealabile. Practic, s-a considerat că dacă ar exista un contract colectiv de muncă care să prevadă aplicarea cercetării disciplinare, deci respectarea procedurii de cercetare disciplinară și în cazul avertismentului, deși nu este obligație legală, având în vedere că contractul colectiv de muncă, practic, ce face? Se mărginește să reproducă textul normativ sau să includă dispoziții mai favorabile salariaților, o astfel de ipoteză ar trebui să devină obligatorie pentru angajator, pentru că e mai favorabilă salariaților. Tot astfel, tot în practică, s-a considerat că dacă totuși angajatorul îl convoacă pe salariatul care este sancționat cu avertismentul scris, deși nu este obligație legală, îl convoacă, este obligat să respecte procedura prevăzută de lege până la capăt sub sancțiunea nulității deciziei de sancționare. Considerăm că perspectiva legiuitorului pur morală, care pune accentul pe faptul pur morală în raport cu avertismentul scris, care pune accentul practic pe faptul că acest avertisment nu ar aduce un aport negativ asupra contractului individual de muncă, nu este tocmai în concordanță cu dreptul la apărare al salariaților, care e un drept fundamental. Și atunci s-a considerat că efectul moral al avertismentului nu este inferior celorlalte efecte produse de sancțiunile pecuniare și pe cale de consecință ar trebui să fie avută în vedere îmbunătățirea textului normativ în această privință, în sensul în care se include obligativitatea procedurii de cercetare disciplinară și în cazul avertismentului scris. În ceea ce privește, aș mai adăuga câteva elemente de drept comparat. Mă rog, în Bulgaria, aici s-au identificat elemente diferite, perspective legislative diferite. Am văzut că există doar avertisment și avertisment de concediere, care sunt aplicate ordinea fiind direct proporțională cu intensitatea reproșului și cu gravitatea faptelor. În Marea Britanie, reglementarea este ceva mai flexibilă. Aici, de exemplu, abaterile minore pot fi, cum este întârzierea la serviciu, poate să fie sancționată chiar și cu avertismentul verbal. În Belgia, regulile care definesc disciplina muncii sunt lăsate în sarcina companiilor prin raportare la legea cadru, da, legea privind regulamentul de muncă, și care, în conținutul căreia se precizează că nicio măsură disciplinară nu poate să fie aplicată dacă atât sancțiunile disciplinare cât și fapta sau abaterile nu sunt prevăzute în regulamentul de muncă. Ca o concluzie, din analiza de drept comparat, am observat că există perspective destul de diferite în ceea ce privește domeniul sancțiunilor disciplinare. Unele sunt mai restrictive, altele au un caracter normativ mai accentuat. Dacă luăm cazul Bulgariei, care delimitează sancțiunile între ușoare și grave, între avertisment și concediere, și aici am constatat că există o încălcare flagrantă a dreptului la apărare în contextul în care nici măcar în cazul concedierii disciplinare nu este prevăzută obligativitatea angajatorului de a respecta procedura de cercetare disciplinară prealabilă. Ori dreptul la apărare este un drept fundamental consacrat în aproape toate Constituțiile. În Bulgaria, când intervine concedierea disciplinară pentru fapte disciplinare grave, intervine subit și fără nicio altă formalitate. La fel, în Marea Britanie am văzut că există diferențe, acolo sunt mult mai multe sancțiuni care pot fi aplicate. Și am considerat și o propunere, am venit cu o propunere de lege ferenda în dreptul intern și am considerat oportun ca de lege ferenda să se includă în textul normativ obligația parcurgerii de cercetare disciplinară prealabilă și în cazul avertismentului scris, pentru a se permite practic tuturor salariaților și a le acorda practic șanse egale în ceea ce privește dreptul la apărare.
Mulțumim foarte mult, doamna profesor. Thank you very much for this very interesting in-course into labor law and especially into possible sanctions that can be applied and the very nice comparative analysis pertaining to different legislations of member states. So I think this concludes our session today. I will hand over the microphone to our dean in order to close this plenary session. But first of all, I would like to thank our guests here today, Mr. Saint-Just, who has been indeed a very good co-host, at least, to say the least, and has very nicely participated and enriched our conference. Thank you.
Thank you, Roxana. I want also to thank our keynote speakers and guests, Saint-Just and Chantal. It was a pleasure to meet them and to participate together at these sessions. I was very pleased to hear their presentations at the beginning, and also that they stood till the end and interacted with the others. I want to thank all the other participants, scholars or practitioners who either here or online they entered and presented their papers, and also they interacted, they debated on the issues. And at the end, of course, I want to thank our partners, mainly the Romanian Society of Business Law. We have a representative here, one just led, the president. They are always together with us in all these conferences on business law, because that's their object activity. And next to them, also, of course, we have some other partners, public institutions, Competition Council, and we noticed today several papers on competition. State aid was the biggest issue to be treated today, but anyway, generally, you know very well that being in the exclusive competence of the European Union, competition of this sensitive area. The Trade Registry of Commerce, with whom we just concluded an agreement to have students over there, and we share common projects. The same, the Tax Council, with whom for some years now, even if we are young, we have concluded the agreement, and we have together a postgraduate study, and we hope this project to develop even more. And insolvency union practitioners, this being institutions who are always present in a way or another with us in the research area, and also teaching some of them. And of course, the media partners that are always present, Juridica.ro, which is the biggest legal platform that we have, and these sessions were actually online on this one. We have both the national and the international conferences open source to everybody who wants actually to watch them, and of course, if they want to interview, they can do also that. And of course, the others, CHS Beck, Universul Juridic, Volters, and other partners with whom either we collaborate in the publishing area, or just in this types of events, organizing events together. I want to thank my colleagues for supporting me in all these projects, and of course in developing this area of European business law, teaching, and as you can see today, also research. Thank you all, and I'm concluding now the sessions of the second edition of the International Conference, European Business Law Conference. Thank you.